Welcome to Looking at Legal Stuff. Today we have 7 hearings in the divorce of a couple, where mom and her lawyer seem to be trying their best to offer dad a fair and equitable division of assets and custody time, but dad keeps accusing them of trying to screw him over. He says mom committed fraud when she filed their joint tax return, that her lawyer sent him fake appraisal documents, that she illegally accessed his bank accounts, and the list goes on and on. He left threatening messages for mom's appraiser and her lawyer, and he claims his former lawyer took his $7,000 retainer and then just ghosted him, leaving him to have to do it himself. And that's just the start of things. He also tells the court wild and rambling stories about attacks upon his person, and he begs the court for unsupervised time with his children, but he refuses to agree to any of the steps he needs to take to get that unsupervised time. Will Dad get his unsupervised visitation? Let's find out.
No, where did she go?
Where did my client go?
I was gonna say, where did she just go? Isn't that kind of day?
It is. It's been kind of like a Monday. Oh, there she is. She's back. Okay. I put the new one up, Your Honor.
Thank you.
I'm not sure he's going to call back in. He was pretty agitated when I put him in the breakout room, so I'm not sure he's going to call back in.
Also, Ms. Sills and Ms. Straub can text him to tell him the court's waiting for him. I think it's important that he hear the order of the court.
Heather, are you able to message him?
I will try.
If you can just let him know that the court is waiting on him to, if he can reappear, please.
He said he's trying to come back.
Thank you.
Yes, he's just muted. Okay.
Court is now in session, bottom of page 3, Heather Straub versus Charles Straub.
For the record, this matter is before the court on the plaintiff's motion to modify custody, parenting time, as well as for exclusive use of marital home. This hearing is being conducted via Zoom. President is Attorney Christina Hills, representing the plaintiff, petitioning party Heather Straub. Ms. Straub is present. Is Charles Straub present on audio?
He's to mute himself.
You need to unmute yourself, Mr. Straub.
I texted him and he said he's trying to join back in.
Okay,
He's here, he just has to unmute.
but he can't hear us if he, maybe you can tell him he's got to unmute himself.
Oh, is he on?
He's
He's
on.
here. But he's not unmuting himself. He can hear us.
He should be
I
able
thought
to
they
hear.
could not hear
No,
us.
he doesn't have any.
Do you hear me now?
Yes,
Am I
Mr.
there
Straub?
now? Okay,
Yes.
yes. It kept my phone was glitching out. I apologize desperately. I am so sorry.
No problem, no problem. Thank
I
you, Mr.
just couldn't
Straub,
get it to go
for
to-
texting. Not a problem
Yeah,
at all.
no problem.
All right, the court stated this matter is before the court on the plaintiff's motion to modify custody, parenting time. Not to modify, but to enter an order of custody, parenting time, exclusive use of marital home. Both parties are present. Mr. Straub is no longer represented by Attorney Suter. And Mr. Straub, you're aware there's mediation scheduled for next Wednesday, April 13th at 1:30 for Mr. Walker. You have that on your calendar, correct?
March 13th.
Yes, sir.
March 13th, okay. 'Cause I know that was scheduled and when you had an attorney, but that still is on. So after you're done with that mediation, then you'll appear before the court for further action, whether you need to set a hearing date. Hopefully the two of you have your own agreement. But the court wants to keep that mediation on as scheduled. And it's not binding, it's just an opportunity to find some middle ground. I think you'll find it to be very helpful. So make sure you appear with Mr. Walker, and you have his Zoom ID number, correct?
Yes, sir.
All right. Okay, the recommendation this afternoon of Ms. Patrick is that mother be granted exclusive use of the marital home. Defendant Charles Straub will provide complete and provide to Ms. Hill, Attorney Hills, their domestic relations financial form. I'm surprised that was not done with the assistance of Attorney Suter. That's usually should be done right at the get-go. I don't know whether she completed that, whether the attorney has that. You get that back from Ms. Straub. If not, do you have that form?
No, and that was why I let her go, because she wasn't working with me. And I've contacted her multiple times about where she left off in the case and what forms in which she has given, and they've ghosted me, and they will not talk back with me about that.
All right. How do Miss Hills, can you scan an email to Mr. Straub as the form they can complete?
Yes, I indicated to him that my office would be sending him a copy of that form, that it needed to be completely filled out, attachments as necessary, and that it needed to be notarized. So
Okay.
we'll also send him an email with the form attached to that effect.
All right. So look for that today, Mr. Straub. We've got, that's a quick turnaround time. You've got to work on that this weekend. Get that back to Miss Hills the day before the mediation.
Absolutely. I will get on that. I asked my lawyer many a times where she had left off, and I didn't know. And I apologize for me not being prepared with that. And
Okay.
I'll have it for you promptly.
All right. Miss Hills, you'll provide to Mr. Straub, Miss Straub's financial form as well?
We've already sent it, yes. You should, if he hasn't received it, he should be getting it any day.
All right. Do you understand, Mr. Straub?
Yes, I do.
You'll be receiving probably any day the completed form that has been completed by your wife, Heather. She and Miss Hills are entitled to one that's completed by you and notarized. So please look for that. I suggest that when you get it to scan email, you print it off, work on that this weekend, get it back to Miss Hills the day before mediation, maybe March 12th, so you can mediate and be prepared March 13th at 1:30. I know you moved out of the house, moved back in, and you understand the recommendation, Mr. Straub.
Sir, to be honest with that, I never moved out. And in that 2 weeks, my kids were actually on a break from school. And not only was I was home alone with them during their whole break. I was never not there for 2 weeks. I don't know where I have picture evidence, and I will submit it when we get to the trial part of this, where I was there every single day.
All right, Mr. Straub, let's assume that you never moved out, that you're there every day. I'm going to take that for granted. You're there every day. The allegations that you're being verbally abusive, you're creating a conflict in the home, chaos, that you shattered your child's phone, you're calling mom names. That's totally inappropriate in the presence of those children. So what do you say to those allegations? That's enough to get her exclusive use of the home, sir.
They are definitely not true to any extent. And the phone was taken away because I found where my daughter was talking about contemplating with other children. And I had sent all this evidence to my lawyer, and I don't know why she didn't get this to the court. All of this.
Okay,
I have all of this
Straub,
evidence.
Mr. Straub, taking the phone away is one thing, but shattering it in the presence of the child is another thing.
I have the phone to prove to you. It doesn't even have a scratch on it. I did not shatter a phone. It has evidence on it of abuse from my wife to my daughter, and it has evidence of my daughter, who's 11, talking about herself, and her friend talking to her about herself. And there were some old men contacting her. And they were like, "Don't tell your mom or your dad." And I was just concerned about the not even the kind of stuff about between Heather and my daughter, but mainly the stuff about the suicide and then my daughter had an episode, and I have a video of it, where she had a panic attack because I took the phone, because she was going to see about this suicide and the bad stuff on the phone, and she had a panic attack. She was just angry, and I have the video. And my lawyer was supposed to submit this, and I'm not sure why she wouldn't take it from me. And I have text. This is why she got fired. And when these videos come out, they will answer and prove that not one of those allegations is true.
Mr. Straub, if your daughter was talking about the proper thing for a parent to do is to sit down with their mother, the other parent, and say, "I've got some concerns, so we need to get our daughter in counseling." Did you do that?
Yes, sir. Yes, sir. And my wife actually.
Hold on, Mr.
Yes,
Straub. Mr. Straub, you talked with Heather and said, "I've got some concerns. Our daughter was. We need to get her in counseling." You told that to Heather?
I texted it to Heather, and I have the text.
Okay, I guess we need to interview. Put your children in the middle of this. I mean, you're saying it never happened.
This never happened.
Straub is alleging that these did happen. Do we need to interview your children? Do you really want to put your children in the middle, Mr. Straub?
At this point, I think you need to see my videos, and yes, you need to interview the children. Yes, because this is not true by any sense of the word. It's actually backwards.
Okay, you better present your videos to Mr. Walker. The court's going to hold off the exclusive use of the home missiles until the mediation on Wednesday, and then when the parties appear before the court then will address that.
Your Honor, I would ask.
Mr. Straub is denying all these allegations. I don't know what to do. Are there interview the children between now and then?
Your Honor, this is clearly not a tenable situation between the two of them being in the same home at this point. Not only per my client, did he move out after he was served, or at least wasn't staying in the home, whether he wants to use different verbiage or not, but he has recently left again. He has not been in the home since February 22nd. At what he said, told us he was staying in his car. My client has reason to believe he's staying with his parents. But it is simply not right for my client to have to deal with the prospect of him simply coming and going as he pleases. They have the right to some peace and some stability as well. February 22nd, after the court's personal liberties injunction was entered on an ex parte basis, he was at the home. That's the day he ultimately left. He was harassing her, mocking her in front of the kids. He dumped out the hot chocolate that she'd made for the children for breakfast that morning. He dumped water all over her laptop computer, dumped coffee all over the kitchen counter. This is the type of thing that my client is dealing with when he's there, and it's all happening in front of the children. So I would ask the court to please order exclusive use of the marital home for my client. He's not even there at the moment, and address that at a review hearing following mediation if we're not successful with mediation.
All right, Mr. Straub, what about that? What about the incident of dumping the hot chocolate, the water? How about it's alleged that you've not been living in the home? Okay, you claim you didn't move out. I don't. You may have different terms of words. Are you sleeping there every night?
I can explain all of this.
So, are you sleeping there every night, Mr. Straub?
Not since lately, because I was in. You can see it. I was involved in a drive-by shooting.
What about the hot chocolate incident?
That was not true. That didn't happen. I have a video. I recorded that entire incident from the beginning to the end. And I actually have a compromise I can make. To defuse the situation, I'm willing to actually let her have the exclusive rights to the home. But I want this to be duly noted when we do actually get to trial, because I have proof and videos that are contradictory to everything she's saying. And instead of getting us all upset and causing all of this, since I have so much evidence, I think that when we get to show the evidence, it'll just be clear. And if you don't want me there because of what she's saying, I mean, I'm fine with that, because like I was going to tell you, as I was involved in a shooting at work, and ever since then, my nerves are kind of shot. As on the same day as the cops were called with me and her, later on that day, I was involved in a drive-by. I was shot by some kids with a machine gun ball, and they're going to get charged with felonies. But it shook me up pretty good, and I'm just with all of this and that, I'm having a hard time just not being freaked out by it, not being anxious, but that's why I haven't been in the home the last week, and they're still investigating who shot me. They haven't found out who they were, and it was all caught on video. And it was a drive-by shooting, and they waited till I walked out of my job, and I walked to my truck, and when I turned my back, I was attacked by someone wearing ski masks, 2 men, and they did a drive-by on me with a machine gun type thing that shot ice balls, and they shot me with a bunch of ice balls. And the police were involved, and they said they're going to charge them with felonies, but I don't think they've been able to catch them. I know they have their car and their license plates, but yeah. So I've just been nervous, because I don't know who was involved in that. Like, it was the same day that me and her had an altercation. I've been nervous to go home because of the drive-by shooting thing, and I'm just saying I don't. And they'd have to talk to the police about it much further. They're still investigating the entire thing.
Well, that gives all the more reason we don't want to put your children in jeopardy. If someone is after you, Mr. Straub, we don't want them coming to your children's home and shooting guns at
what if Heather had it, or what if Heather did it?
Well,
she has everything to gain.
All right, Mr. Straub, you've agreed, so the court will order that and grant Heather exclusive use of marital home. You need you need a box of clothing. Can Mr. Straub box up some of the basic clothing that he has at Miss Hills?
And she can drop that at my office and he can pick it up.
Okay. When can that occur? Maybe Friday?
It would need to occur between 8 and 12. My office is closed. We work remotely on Friday afternoons, but if you can be there between 8 and 12, she can have the box to us. Correct? Is that correct, Ms. Straub?
Yep.
Okay, Mr. Straub, can you be at Miss Hill's office or have your parents or somebody stop by and retrieve some of the box of basic clothing?
Yeah, that's fine.
Okay, your office is not open after noon, so plan on Friday. make a mental note Friday of this week. That's March 8th between 8 a.m. and noon. Have your, if you're working, have your parents pick that up. But yeah, you can get all your videos together. In any event, of course, so the court will in fact adopt this recommendation. Plaintiff mother's granted exclusive use of marital home. With that, if Ms. Straub feels comfortable changing the lock, she can do that, Ms. Hills.
Thank you.
Mr. Straub, that doesn't mean she gets a home. She just has exclusive use of it. You understand?
Yes. Yes.
If in fact she didn't vouch,
That was kind of what I was
we've got to
confused
have it.
about. Yes,
If in fact she doesn't vouch your interest, then obviously it'll have to be liquidated and sold, but we'll take one step at a time. The things we're going to talk about in mediation are property settlements. Ms. Hill, just for the court's information, there's obviously real estate to be divided. Is that correct? Personal property?
Real estate, it's my understanding, I didn't look at all the property issues for today's purposes, but I believe my client owned the home prior to the marriage, so there's an issue of what constitutes Mr. Straub's marital interest in the property. Some personal property issues. I believe there are retirement benefits which would need to be addressed, as well as the custody parenting time. I don't believe alimony or spousal support should be an issue, but I'm not certain what Mr. Straub is requesting.
Well, what about, is there a significant unsecured debt like credit card debt that needs to be divided?
I don't believe is it, Heather?
Not significant, but there is credit card.
Okay. Okay, all right, Mr. Straub, do you have any questions?
and I'm concerned about our
I'm sorry?
yes, sir. I am concerned
You're breaking
about
up,
our
Mr. Straub.
taxes. Me and her file mutually with our taxes. I am concerned about it's about our taxes. Me and Heather's taxes. Are we about filing those?
Okay, you can talk about that on Wednesday of next week, the mediation.
Okay.
You normally would you divide the proceeds, or the best you can do with the proceeds, if you get a refund, is pay off the credit card
Okay.
debt.
Now, can I request that she pays for the lawyer fee, because what I've paid in the lawyer, and my lawyer did request that, and also can I still get a chance to maybe get a lawyer with what happened
Sure.
with mine?
You can get a lawyer at any point in time. You can get a lawyer at any point in time, but no, there's no, your attorney's not right here to request attorney fees, so no. Ms. Straub is not going to pay for your attorney. Anyway, but if you want to get another attorney to appear with you on Wednesday, that's fine. Or even if you have any, at least consult an attorney. It's probably wise to at least consult an attorney. The attorney could give
Now,
you some
see,
idea
Okay.
of what to expect.
Yes, sir. Yeah, I had hired an attorney and I paid them $7,000. And then they took all the information and did not give it to you. So I'm gonna have to sue them too for what has happened here. So they did this entire case and then for me. And then I paid them I have all of the bills and all of the where I can show itemized everything that she did, and she was supposed to turn into me and she did not.
Well, Mr. Straub, you signed an agreement that she could withdraw. You should have not have signed that until you got a refund of your retainer or got some of your documentation, or just said, no, I want you to stay in the case.
Yeah, it was my fault. I'm not. I needed a lawyer because I'm not good at that stuff, so they tricked me. So yeah, I guess I'm gonna eat that one.
Okay, so again, pick up your box.
I'm not a smart guy.
Mitchell's office on Friday, March 8th, between 8 and noon. You cannot go over to the house. You understand that? And then
Yes,
we will
sir.
talk to you after your 1:30 mediation with Mr. Walker and get that financial form to Ms. Hills by the day before. All right, anything further this afternoon, Ms. Hills?
My understanding the court will review this after the mediation.
Yes, we got it in our doc. We'll have the file up here.
Very good. Thank you.
And if Ms. Straub wants to change the locks at home, she can do that at this point in time.
Okay. Thank you very
All
much.
right, right, that'll conclude this matter.
Awesome.
We'll see you then on
Thank you.
Wednesday afternoon, Mr. Straub.
Okay, thank you.
You're welcome. Right. That'll conclude this matter. You can all zoom out. Thank you, Ms. Patrick.
Now session, Heather Straub versus Charles Straub.
The record of this matter is before the court contains a pre-trial conference. Subsequent parties have engaged in mediation. Actually, it's an initial pre-trial conference. Subsequent parties have engaged in mediation with Mr. Walker for the court this afternoon. This pre-trial is being conducted via Zoom. Attorney Christina Hills is present, representing the plaintiff Heather Straub, and both Mr. Straub both appear to be present. Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Ms. Hills, the court has been informed that parties have made significant progress this afternoon, but have scheduled a continued mediation on the May 1st at 1:30. Is that correct, Mr. Walker?
That is correct. Both parties are engaging the services of an appraiser, and the amount of equity in the marital home remains our biggest hurdle to resolving the case in its entirety today. We do have an agreement as to most other issues, and I'm happy to put that on the record. We also have reached a temporary agreement pending further mediation and sort of seeing how this agreement goes with respect to the children. This agreement would be incorporated into a temporary order, which would be without prejudice as to either party.
Very well. Mr. Straub, is that all correct?
I believe so.
I'm sorry?
Yes, I believe
Okay.
it, yes.
All right. Okay, so Ms. Hills will state in the record what she understands to be your temporary agreement. So listen carefully. And after she does, I'm going to ask you to confirm your understanding of that, okay?
Yes, sir.
And I guess before we proceed further, Mr. Straub, even though Ms. Hills is helping facilitate resolution of this matter, she will prepare the what's ultimately called a judgment divorce. Ms. Hills represents your wife, Heather, so her loyalty is live with Heather. Do you understand that, sir?
Yes, sir.
Okay. Do you have any questions or concerns before we continue?
Yeah, I just want to make sure that what she's saying is actually what we did go through in the court and with the mediation, because I noticed when we were sitting down with the mediation guy at the end, Miss Heather's lawyer and that guy had a hard time making sure that they're on the same page with what we agreed upon in the mediation, and then she's kind of going over it now after we've already agreed on it, and it's kind of confusing.
Okay, so Ms. Hills is going to state what she understands to be your agreement. So listen carefully. You got a piece of paper and a pen there. You have presumably made notes. So listen carefully. Ms. Hills will state what she understands to be your agreement, and then I'll turn to you and ask you whether or not it's a correct statement of your agreement. Okay, Ms. Hills.
Thank you, Your Honor. Your Honor, the parties have agreed that they will have no contact with each other except as to the welfare of the minor children. They will use app close only for communication except in an emergency. We are going to mediate further with Mr. Walker on May 1st at 1:30. We are going to temporarily and without prejudice agree to joint legal custody. We are not at this time addressing physical custody. Parenting time is going to be on a 50-50 basis. That will start with Mr. Straub having the minor children from Friday, the 15th of March through Monday, the 17th of March. Thereafter, we're going to be utilizing called a modified 2-2-3 schedule. The first Monday, Tuesday, after the 15th through the 17th, which would be the 18th and the 19th, those overnights of parenting time would be with Ms. Straub. Then father would have the Wednesday, Thursday overnights of parenting time, and Ms. Straub would have that following weekend. So putting it in plainer terms, the parties are going to flip-flop the Monday, Tuesday, and the Wednesday, Thursday overnights and alternate the weekends from Friday until Monday morning, generally to school. The person who's starting parenting time is going to be doing the pickup if it cannot be done at school. The exchanges would be in the driveway or curbside, if possible, depending on what's appropriate for the safety of the children. There would be no communication between the parties at the exchanges. That could be done through app close prior to or after the exchange. Mr. Straub has agreed that until he finds his own place, he's going to be living at his brother's home for purposes of his parenting time. That does not mean that he can't leave his brother's home with the children. That simply means that's where he's agreed to live until he finds his own place. Parties would be using the friend of the court holiday schedule unless they otherwise agree in writing. However, the holiday schedule would not commence until Memorial Weekend. So the regular parenting schedule, the modified 2-2-3 schedule would be in place for spring break and Easter weekend. Neither party would interfere with the children's ability to contact the other parent. And
I don't know where you're coming from with this, but I have to stop you here. We didn't agree on any of the stuff that you're talking about here. A lot of this stuff is not what it was written. I'm sorry to interrupt, but you just keep going, and I can't say yes to anything because you've said so much, and a lot of it isn't what we talked about. Sorry.
I'm going to let Mr. Walker take over at this point.
Please.
Your Honor, all I can say is that we did have an agreement when we left my mediation. So far, from what I've heard Ms. Hills state, she has not deviated from that agreement yet.
She said that we didn't agree on the custody, but I thought we had agreed.
You have joint legal, which I believe Ms. Hills stated,
Yeah.
but you haven't agreed anything on physical custody, which we didn't talk about physical custody. We didn't agree on anything when it comes to that.
I thought that's what we meant by we each have them every other week.
Yeah, Ms. Hills has not gone over parenting time yet. She will get to that. That's separate.
Okay, I apologize for the misunderstanding.
So, Mr. Straub, we're not dealing with physical custody. It's not necessary. It's just the joint legal means that we make equal decisions regarding the important decisions regarding the welfare of your child or children, like medical treatment decisions, education, so forth. And then, so we're just addressing parenting time, which is a temporary basis. Between now and when we come back, temporary basis sounds like pretty much equal parenting time.
Yeah, that's what I thought it was. And I'm sorry for the misunderstanding. I didn't understand how it was being phrased. I'm sorry.
And again, if in fact we need to tweak this or modify this when we come back on May 1st, we can do that. This is temporary between now and then. All communication be app close. Joint legal, which means if the child's with you and you get in the emergency room, you need to immediately notify mom, vice versa.
Yeah, that's fine.
So this is just between now and May 1st. It's temporary. Without prejudice, you can, if you want, you can still hire an attorney. You can argue these things, but it sounds pretty reasonable so far. So, do you want to go through the parenting time schedule again, Ms. Hills?
Sure. What we call it in general family court attorney terms, is a modified 223 schedule, whereby the parties would alternate the weekends from Friday through Monday morning. Typically, that would be to school, although we do have times in place for when the children don't have school, and I'll get to those in just a moment. But Mr. Straub would have the weekend of Friday, the 15th of March through Monday, the 17th of March. Then Ms. Straub would have the 18th and the 19th overnight. So the first Monday, Tuesday would be hers. Then the Wednesday, Thursday would be Mr. Straub's, the 20th and 21st. Thereafter, we're going to be flip-flopping those Monday, Tuesday, and Wednesday, Thursday, so that the following Monday, Tuesday, Mr. Straub would have those overnights, and the following Wednesday, Thursday, Ms. Straub would have those overnights, and we continue to alternate the weekends, Friday through Monday. If there's no school and Ms. Straub is working, then the exchange would be after she is done with work. If there is no school for the children and Ms. Straub is not working, or Mr. Straub is not working once he gains employment, then the exchange would be at 9:30 a.m. or another time to be agreed by the parties, depending on Mr. Straub's work schedule, whatever that might be. So I believe, it is my understanding that Mr. Straub agreed that for the first week of the 50-50 schedule, so starting Friday, the 15th, because it has been a couple of weeks since he's had parenting time with the kids, that he has agreed that if the children ask him to go back to moms, that he's not going to interfere with that for only the first week. After that, it will be, there won't be that provision in place. If the children ask to go back to moms, he does not have to agree to that at that point unless he chooses to. And that's simply something that he agreed to for the comfort of the children, as I understand it. So that is the entire agreement, a temporary agreement as it relates to the children. And then we also do have a partial property settlement that we do wish to put on the record today.
Okay, let's first of all stop there, Ms. Hills. Mr. Straub, so far, as Ms. Hills actually stated, you're a temporary agreement without prejudice in terms of parenting time between now and when we get back on May 1st.
Yes, that is fine. That is what we agreed upon, and I just thought that was an agreement of like the other physical custody. I was mistaken, but that is the agreement, and that's fine.
Right, and this court doesn't deal with physical custody. You know, when the children are with you, you make the decision what time to go to bed. When they're with mom, mom makes the decision what time to go to bed. Those mundane decisions. Who's ever the parent and whose possession of children are makes those decisions. All right, so we got to past that point, Ms. Hills, and there's some other agreements relative to the overall divorce action.
There are, Your Honor, and we did have some temporary agreements, orders already in place, and those would remain in effect with regard to the, primarily it's the exclusive use of the marital home, as well as the personal liberties injunction. All those prior orders that are not in conflict would remain in full force and effect.
Do you understand that, Mr. Straub?
Yes.
So any prior orders which are not inconsistent with this order will continue in full force and effect. Understood?
Yes, sir.
All right. So with regard to the partial property settlement, we are not addressing child support at this time. That is being reserved. We are not addressing spousal support at this time. We are not addressing the amount of equity in the marital home that is owed to Mr. Straub, with the exception of a credit for some marital debt that Ms. Straub is taking on. And we do have a specific number for that. So we would include standard statutory language regarding life insurance. Mr. Straub is entitled to 50% of the marital portion of Ms. Straub's Panera Bread 401k. That would be divided by a qualified domestic relations order. His portion would be subject to gains and losses after the division date, which would be the date of entry of the judgment of divorce. The qualified domestic relations order would be prepared by Ms. Pastrana, and the parties would split the cost of preparation of the qualified domestic relations order and any administrative costs equally. Other than that, each party is awarded the retirement accounts in his or her own name, if any. With regard to real estate, Ms. Straub is awarded the marital home at 8 Drive, which she owned premarital. She is going to assume the mortgage, indebtedness, taxes, all other expenses of ownership, and will indemnify and hold Mr. Straub harmless from that debt. He is not on the mortgage. I think both parties agree with that. He is not on the deed either. So once the divorce is final, he is going to convey his interest in the property to Ms. Straub by giving her a recordable quitclaim deed. And she is going to pay him a sum to be determined for his share of the marital equity in the marital home. And that amount, whatever half of the marital equity is, that will be adjusted downward by $3,513 as of today's date. And that amount will not change. I said as of today's date, but I want to make it clear that number is fixed, and it relates to a credit card, and I'll address the specifics of his use of that credit card moving forward in the debt section. But whatever his half of the marital equity is, that will be adjusted downward by $3,513. With regard to, and I should say, again, both parties have appraisals pending, and we hope to have those by the date of the next mediation with Mr. Walker, so we can get that issue resolved as well. With regard to personal property, parties are going to agree to divide their personal property with some specific exceptions. And as to all of the personal property that I'll mention, each party agrees to pay any debt owing on that property and hold the other harmless from liability on that debt. Ms. Straub is awarded the 2020 Chevy Equinox, the 2011 Chevy Impala, and Mr. Straub has agreed to provide her with the key to the Impala if it is in his possession, and he's agreed to exercise some due diligence in trying to find that for her. Mr. Straub is awarded the 2001 Dodge Ram pickup and the 1983 Starcraft Super Sport boat and boat trailer. He is additionally awarded all of his guns, actually all guns, the 32 and the 40-inch TVs, the leftover solar panels, 2 100-amp lithium batteries, 2 boat motors, and the third being awarded to Ms. Straub, which came to her from her grandfather. His hunting gear, the kayak, the power tools and the hand tools, the fishing gear that's not awarded to Ms. Straub, and the Cub Cadet lawnmower. I don't believe I missed anything there. Ms. Straub will be receiving the generator, the refrigerator and stove, her wedding rings, her fishing poles, the fishing gear that she got from her grandfather, the children's 2 cell phones, once any pending CPS investigation, if any, is closed, and her grandfather's boat motor, as I mentioned. With regard to bank and financial accounts, each will receive all interest in the bank accounts in his or her own name. They do have a Robinhood financial investment account, and Ms. Straub is going to be paying Mr. Straub 1/2 of the value of that account as of the market close on the date of entry of the judgment of divorce. Regard to marital debt, they're each going to be responsible for the debt in his or her own name. Again, that $3,513 credit on the equity accounts for Mr. Straub's share of the marital debt as of this date. And if he is going to be able to continue to use the Cabela's credit card on which he is an authorized user, that card is in my client's name. He will be solely responsible for paying for any charges that he makes on that card as of today's date and moving forward until this matter is final. If he has not paid those amounts that he charges in full to Ms. Straub by the date of entry of the judgment of divorce, then she will be entitled to a further credit against the equity in the home in whatever amount he has charged on that card. This card is nice because it indicates not only the charge that is made, but who has made the charge. So if it is Mr. Straub, it's going to clearly say Charles made that charge with his card. So there should not be any sort of question as to whose charge is whose. But she will be entitled, if he's not already paid her, to deduct those amounts after today's date from his share of the equity in the marital home. As of the date of entry of the judgment of divorce, he has agreed to not use that card at all. Parties have just very recently filed their 2023 taxes, and they are going to split the refund such that Mr. Straub is going to receive the first $2,000 of the total refund, state and federal, and then the parties are going to equally split the balance of the total refund remaining after he gets the first $2,000, and that's to equalize the bank accounts in this case. Parties would acknowledge not receiving any tax advice from attorneys. Tax exemptions for the minor children is they have 3 minor children, and for even tax years, Ms. Straub is going to take 2 exemptions, Mr. Straub 1, vice versa for odd tax years. When there are 2 exemptions, they will each take 1, and when there is only 1 exemption remaining, again, Ms. Straub will get that exemption for even tax years and Mr. Straub for odd tax years. Each would pay their own attorney fees. Ms. Straub would be entitled, if she so chooses, to have her maiden name of Saunders, Saunders, restored to her, and I believe that is the extent of the partial agreement as of today.
Thank you, Ms. Hill. So the only remaining issues would be determining child support, spouse support, as well as Mr. Straub's interest in the half of the marital value of the real estate, correct?
Yes, figuring out what is his half so that we can come up with the appropriate amount with the credits that Ms. Straub is entitled to, correct?
I do have
Each
a question.
party?
I'm so sorry. The other 2 credit card debts, were those also going to be rounded into being removed off the equity amount? Because there's 3 credit cards.
Josh, help.
Thought we were cutting all of them in half.
I did not add those in. You're muted, Josh. I did not add those in, but that could
That
have
was,
been an oversight.
Ms. Hills, you did add that. That was part of the initial amount of money, the fixed amount that you had stated that was going to be taken off of what Heather owes to Charles for the equity in the home. That was for for all 3 credit cards plus the $100 extra towards the Cabela's.
The $35.15 was just the Cabela's one. That's half of just the Cabela's.
Okay. That's supposed to also be with the Coles and the card member services.
All right.
All three are supposed to be split equally.
Okay, so and that's as of today's date. So Heather, I'll need you to get me those so I can get those figures to
Yep.
Charles. And then we would add those, and for Mr. Straub's one half of those, then we would deduct that. We would add that to the $3,513, which would be deducted from the equity and his share.
I have those amounts unless you just want me to send them to you later.
You can go ahead and state them for the record.
Okay, so the Kohl's one was, oh man, $625.53, and the card member service was $3,221.78.
I'm sorry, say that card member services one again.
$3,221.78.
Okay, so we'll provide Mr. Straub with proof of those account balances as of today. And I think we would just need to confirm with him that he's agreeable with those amounts being deducted as well. His half of those amounts being deducted as well from the equity, his share of the equity in the marital home.
Yeah, I agreed, as long as I get statements to those accounts, because I don't have statements, so I can see purchases.
That's not a problem.
Okay, so I'll figure the math out there and send both parties a letter confirming my understanding of the figures and what we've agreed to today.
Right. Ms. Hills, how will the parties determine the marital value of the real estate? They're both going to submit an appraisal, and we'll try to find some middle ground between the two appraisals, and then look at what the increased value of the home from and after the date of the marriage.
Yes, my client is getting an historic appraisal as well as a current appraisal. So hopefully Mr. Straub will do the same. But yes, we're hoping that we can get some assistance if we need it from Mr. Walker in coming up with a final resolution on May 1st.
Okay. So Mr. Straub, you understand we basically need an appraiser, unless of course, obviously if Heather's going to hire a certified appraiser, you may be comfortable relying upon that appraiser but if you want your own opinion, then you can pay for it. And obviously the appraiser needs to determine what the current value is and what the value was as of the date you got married.
Yeah, I'm down to get my own appraisal.
Okay, but that appraiser needs to be instructed what you need. It's not just a fair market appraisal. They need to determine, what'd you call it, Ms. Hills, a historical appraisal?
Historic appraisal and a current appraisal, yes.
Okay,
So
yeah,
historical appraisal and a current appraisal. So you need to provide that to appraiser with the date of your marriage. With respect to this real estate. Now, obviously, the appraiser going to want to see the home, so you need to communicate with Ms. Straub on app close and let her know the name of the realtor, and so Ms. Straub can make arrangements to have that realtor examine and go through the house. Right. So, Mr. Straub, we've already dealt with on a temporary basis parenting time and joint legal custody, which I'm glad to see. Parenting time is pretty much equal. With respect to the other issues, is that a correct statement of your agreement in terms of the property?
Yeah, Miss Straub can have full uses of the home, and if she wants to buy the home out, I have no problem with that. It's best for the children.
Well, this is an agreement. She's going to keep the home. She's going to be word to her. You're going to sign a quick claim deed at time of entry of the judgment. She's going to pay you one half of the marital value of that home, less this figure to be determined on the credit cards. That's what the original was, what, $3,513?
Yes, Your Honor. I just did the math. The number I come up with now is $5,436, of course, subject to Mr. Straub seeing the statements.
That wasn't the half.
That was half, yes.
Right. So whatever the value that's determined, Mr. Straub, by the appraisals, they're going to deduct the $5,436, and she will pay you that difference. What's the time frame for paying that, Ms. Sills?
Good question. Judge, can you pay that within 120 days of entry of the judgment, Heather, in case you need to get a home equity line of credit?
That would be good. Yeah.
Okay. 120 days or sooner if she can.
Okay, so Mr. Straub's being suggested she'd have 6 months in which to pay that in order to secure an additional loan in order to come up with that sum of money. Any objection to that?
No, sir.
No?
No
Okay,
objection.
Mr. Straub saying no. That's pretty typical, Mr. Straub. Their side has a reasonable time frame, 6 months, in which to get that financing together. But again, the other terms of the agreement that would be final in terms of the division of the personal property that was referenced. The pension, each of you keep your own, except you're going to get one half of the marital portion of Heather's 401k with Panera Bread as of the date of entry of the judgment of divorce. The tax dependency for the children, all those other issues, are those all acceptable?
Yep. And then I didn't know if I call her, but I also get the $2,000 credit for the 4,000 in Heather's bank account. I'm not sure if she said that.
I did. We take that off the top of the tax refund so that the parties are just splitting the balance of the tax refund after he receives the first $2,000. The tax refund is going to be about $5,300, I believe. Is that correct, Heather?
Yes, yes.
So yes, you'll get the first 2,000 of the tax, the 2023 tax refunds, and the remaining balance will be shared equally, Mr. Straub. But again, if this is your agreement, then you'll be bound by that. We're not going to re-argue these issues later on down the road. Just the limited issues, the value of your home and the real estate, child support and spousal support. Those are the main issues. Everything else has been addressed. Is that all agreeable?
That's agreed.
Okay. Do you have any questions for the court or any questions of Ms. Hills?
No.
Right. Ms. Hills, you want the party sworn?
I do, Your Honor. I was wondering if you
Right.
wanted me to do proofs today in addition to questioning about the partial settlement
Sure.
and temporary agreement.
You might as well can take some sworn testimony. Mr. and Mrs. Straub, can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Heather, would you say?
Mr. Straub?
Yes,
Mr.
I
Straub,
do.
we didn't hear you.
I do.
There you are. Okay, we can hear you. Thank you. All right, Ms. Hills, you can begin with Ms. Straub, please.
Thank you. Ms. Straub, would you state your name for the record, please?
Heather Straub.
And you are the plaintiff in this case, correct? Meaning you filed,
Correct.
right? At the time you filed your complaint for divorce, had you been a resident of Michigan for at least 180 days
Yes.
and of Monroe County for at least 10 days?
Yes.
Is it true that there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved?
Yes.
Are you pregnant?
No,
And you have 3 minor children, is that correct?
that is correct.
And were their names and ages accurately set forth in the complaint that you filed in this case?
Yes, they were.
Right? And there were no other children born to or adopted by you and Mr. Straub?
No.
Have you heard the agreement that we reached with regard to the children on a temporary basis and without prejudice?
Yes.
And do you have any questions about any of those terms relating to the children?
No.
And do you believe at this point in time that this agreement this temporary agreement is in the children's best interest? At this point in time?
At this point.
Okay. All right. And we'll be discussing it further, possibly at mediation on May 1st. You understand that?
Yep.
And if there are any emergencies that come up, then you'll contact me about that, correct?
Yes.
Okay. All right. You have, so are you asking the court to adopt the terms relating to the children into a temporary order?
Yes, I just want to make sure that they are comfortable with everything. And as long as everything runs smoothly, then that's fine with me.
Okay, but you understand that it's only for the first week of this 50-50
Yes,
arrangement
yes.
that Charles would have to bring the kids back to you, or you wouldn't be able to come and get them if they express to him that they're uncomfortable being
Yes, I
absent.
understand that.
Okay. All right. Do you have any other questions or concerns relating to the temporary agreement with regard to the children?
Nope, as long as the children are able to contact me if they want to while they are with Charles, I'm fine.
That was part of the agreement, and that goes the other way too. If they wanted to contact their father, then you would need to let them do that.
Definitely.
Okay. And have you also heard the partial property settlement that I read onto the record and was clarified by just about everybody today?
Yes.
Right? You understand that you do not have to enter into a partial property settlement? We could have waited until we had everything agreed to?
Yes, I understand.
You believe that it was in your best interest to put this partial settlement agreement on record today?
Yes.
You understand that, excuse me one sec. Excuse me. With regard to this partial property agreement that we've put on record today, once the court accepts that, there's no going back as to those provisions. Those are unlike the provisions relating to the children, which are adjustable based on their best interest, but there's no backing out on these property provisions. You understand that?
Yes, I do.
All right. And you are asking for the court, when the time is appropriate, to incorporate this partial property settlement into your judgment of divorce?
Yes.
All right. And saying that, do you have a full understanding of all of the terms of the partial property settlement?
Yes, I do.
Have you had enough time to think about all of those terms?
Yes,
And do you have any questions about those partial property settlement terms right now?
I do not.
And you were a full participant in the mediation today?
Yes,
Are you satisfied with my services on your behalf?
yes,
And thank you. And you understand that we're not addressing child support, spousal support, or the actual amount of equity in the marital home, marital equity at this point.
yes,
And those will be determined at a later date.
that is correct.
And you still wish to move forward with this partial property settlement?
I do. Yes, I do.
Thank you. I have no further questions.
Thank you, Ms. Sills. Mr. Straub, could you please state your name and current mailing address for the record?
My name is Charles Straub, and I currently reside now Dundee, Michigan.
Thank you, Mr. Straub. Did you hear the excuse me, did you hear the testimony of your wife Heather this afternoon?
Yes,
You can put your hand down. Was her testimony true and accurate to the best of your knowledge?
yes,
Okay. Once again, do you understand with respect to the temporary agreement on parenting time is temporary? That can owe subject to modification as circumstances change. But with respect to property, do you understand that this will be a binding agreement relative to property? The only remaining issues would be spousal support, child support, and the value of your equity in the real estate.
yes, I understand that and agree with it. Yes,
Okay. Do you have any questions for the court?
no,
Do you have any questions of Ms. Hills?
no, sir.
Ms. Hills, do you have any questions, Mr. Straub?
No, Your Honor. Thank you.
So the court would encourage when both sides get their appraisals, share the appraisals so that can be reviewed ahead of time in advance of this May 1st mediation. Hopefully you'll have those well in advance of May 1st mediation, and perhaps so you can see the other's values before then. In fact, I'm sorry, Mr. Straub, the court's going to mail out a notice for this continued mediation on May 1st at 1:30 with the continued pre-trial to follow. Can you give me your address once again? I did not write that down in this file. We have a Plank Weld Drive address in Monroe, but your address now in Dundee, is that correct?
Yes, my new address as of today.
What's the zip code, Mr. Straub? Do you know the Dundee zip code offhand?
I think it's 48151.
Is that right, Nancy? Okay. All right, again, do you have any questions, Mr. Straub, of the court or Ms. Hills?
No, sir.
All right, based upon the testimony that's been presented this afternoon, as well as plain file this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the obvious matrimony have been destroyed. There's no reasonable chance of reconciliation. The court will adopt the partial settlement agreement reached by the parties and continue this matter for further proceedings on May 1st, subsequent to the 1:30 mediation with Mr. Walker. Thank you, Ms. Hills. Thank you, Mr. Walker, for your time and attention this afternoon. And Mr. Straub, I will assure you, and Ms. Straub, the best resolution of this matter is one in which you both work together and reach your own agreement. Far better off to have court decide these matters. Ms. Hills is very capable. She's moving you forward in a responsible, fair fashion. And with respect to parenting time, your children will do well and they'll thrive if you're both on the same page. So communication is the key. Please work with each other. Mr. Straub, it's really important that the children feel comfortable that they can call their mother when they're at your house. Make it good for each other and the children, please. So with that, you can zoom out, have a good rest of the day, and we'll see you on May 1st.
Thank you, Your Honor.
You're welcome. For the record, this matter is before the court on the defendant, Charles Straub's motion to vacate a divorce decree. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, along with her client, plaintiff Heather Straub. They're both present. Mr. Straub apparently has failed to appear this morning. He's not contacted the court. This matter was scheduled for 10:30. It's now 10:45 a.m. Court was quite confused as to what Mr. Straub was kind of relief he was seeking. There's been no divorce decree entered in this case, correct, Ms. Hills?
That is correct, Your Honor. We had a partial settlement agreement, which is reflected in the transcript that I ordered.
Okay. It appears that Mr. Straub is alleging fraud on the part of Ms. Straub, and that she apparently forged his name on tax returns. That's an issue that Mr. Straub can address with the Internal Revenue Service. That partial agreement, I know we have an order that was entered with us bills from the agreement in place by the record of March 13th. Did that agreement also address sharing of the tax refunds?
It did, in a very detailed manner, Your Honor. The motion that Mr. Straub filed, which we feel strongly should be considered frivolous by the court, addressed not only the fact that the tax return had been filed, but a very detailed distribution of that tax return, which favored Mr. Straub. Court asked him if he had any questions, went through the entire usual waiver of counsel, asking him if he had questions or anything else, any confusion about anything that day. He indicated he did not. Said a lot of things in the motion to the contrary, but he didn't that day when he was under oath and the court was questioning him. So my client filed the tax return in the way that she's always filed the tax return. We disclosed it at mediation. We disclosed it on the record when putting the partial settlement agreement on. The terms of the distribution, again, were discussed in detail and placed on the record, and he did not say anything at that point in time.
Thank you. The court's not had a chance to review that transcript, but I did review the order. The court notes that there's continued mediation with Mr. Walker May 1st at 1:30, but their pretrial thereafter. Is that correct?
Yes, Your Honor. And we still have the issues of he's asking for spousal support. He's asking for child support. And the other issue was the value of the equity in the marital home.
Okay. Well, at this point in time, since Mr. Straub failed to appear for his motion, the court will enter an order. It's presented by Ms. LaPrade that denies his motion. Chris, failure to appear.
Your Honor, we are asking for attorney fees. We did have to prepare a response to this motion. I had to talk with my client about it. I had to order the transcript. The transcript alone was approximately $70, $69.70, I believe. I'm asking for $520 in attorney fees for all of the work that I've had to do to prepare for today.
Of course, now received a response, which actually surprised me. So because normally do file a response. I thought maybe you were not served with the motion. So I've not seen a response.
I did prepare and file a response, Your Honor.
Typically, your officer drops one off here at the court, so it must be down in the clerk's office. It's not part of the court file yet. I'm not sure when that was filed, but anyway, at this point in time, the court will reserve a request for attorney fees, Ms. Hills. Mr. Pratt, you can add that to this order. The court reserves the request of Ms. Hills for attorney fees.
Yes, sir.
Certainly, the court's inclined to grant some attorney fees to Ms. Hills for his failure to appear in his own motion, causing you to. Well, strike that. Perhaps it's best if the court address that this morning. Ms. Hills, can you break down your requested amount of what, 500? And
1 hour in the preparation of the response, review of the motion, discussion with my client. I calculated approximately a half hour for this morning. We're at 20 minutes. I always log in a couple of minutes early. $70 for the transcripts. I charge $300 an hour, which I believe is a very reasonable rate in Monroe County currently. And so that totaled, the time totaled $450 and the transcript another $70, which was the $520 total.
All right. Further reconsideration, the court will award attorney fees to Ms. Hills, amount of $520. I think it's add a sense, Mr. Brad, that the court orders of Mr. Straub paid to Ms. Hills attorney fees and costs unnecessarily incurred the amount of $520.
What time frame would the court allow him to pay those?
Order that to be paid on or before May 1st.
Thank you.
2024.
All right. We may be filing a show cause as well, Your Honor, relating to violation of the exclusive use order. I would set that. I believe we have a pretrial set for after the mediation. He went to the marital home and retrieved property that he was awarded in the partial settlement agreement that he was attempting to vacate, and then sent me a couple of taunting emails that I couldn't do anything to stop him as well. So that's where we're at with him at this point.
So he entered the home without permission?
He entered the property and retrieved the boat without permission.
Okay. Okay. And it may be best to go ahead and file a motion what's appearing on that date. So at least that issue is can be addressed at time mediation. He's aware that that's an issue.
Yes, Your Honor.
So after further reconsideration, the court will in fact award attorney fees about $520, attorney fees and costs.
Very good.
Paid on before May 1st, 2024.
Thank you, Your Honor.
Right, that will conclude this matter. You can zoom out.
All right.
This matter is before the court for continued pretrial conference subsequent to mediation. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, representative of the plaintiff Heather Straub, and Ms. Straub is present, and defendant Charles Straub is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Court has been informed by Mr. Walker that Mr. Straub does not wish to mediate this afternoon.
My understanding.
All right, Mr. Straub, you should have told me that. We're wasting everyone's time. If you said, no, Judge, I want a trial date, I don't want to mediate, nothing to discuss. Could have avoided wasting Ms. Hill's time, Mr. Walker's time. All right, so as the court recalls, and I will assure you, Mr. Straub, the best resolution is one in which you participate. You go to trial, the courts can make the decisions. And normally most people want to have some input in those decisions. And in the court's recollection, there's only three main issues: child support, spousal support, and defendant's interest in a marital home. Whatever the interest is to be, was reduced by $5,436. Those are only four issues as the court recalls. Is that correct, Ms. Hills?
So those are the main issues. There are a couple of miscellaneous issues in the meantime. We have filed a show cause relating to Mr. Straub's removal of some personal property from the marital home in violation of the exclusive use order, and appearing at the marital home in violation of that order. We also, he had scheduled a hearing that he failed to appear for, asking to vacate the previous agreement. And the court ordered $520 of attorney fees to be paid by today. Granted, he has until the end of business today, but I'm not optimistic that that payment is going to be made in a timely manner. Mr. Straub also owes me interrogatory answers. Those are well overdue at this point, and I would certainly need those prior to any trial date.
Right. All right, so Mr. Straub, there's some preliminary matters that need to be addressed before we can schedule a trial date. The interrogatories, when can those be returned to Ms. Hills? Overdue.
As soon as I can get to them, I apologize. I've had a lot I've been trying to do. And as for the not telling you about the date, I just made the decision just now when I was talking to her, when all of this went down earlier today. I would have told you earlier, but I had just made a decision that this is the route I wanted to take. For the record, I wasn't doing it for like out of disrespect or to anyone. It was because of the information between me and Ms. Hills wasn't getting sent properly in a way to where I felt like I could. I don't even participate, honestly. So I do feel like you could do a better job than at the point of where I'm at with it. So I feel like it's helping and not wasting people's time by just having the trial just go ahead. And I'll get to those things as
Mr. Straub, your language is not real clear. I'm having a hard time deciphering your language. Perhaps I give you a phone number you can call in. It'll be much clearer. It's not your language is not picking up. I don't know, Ms. Hills, did you follow everything Mr. Straub just said?
It was difficult, but I think I followed what he said.
Okay, the court could not. Mr. Straub, if you got a piece of paper and a pen, I'm gonna give you a phone number. You can call in, appear by audio.
Just 1 second. I mean, I'm not sure why it's not working properly. Can you hear me better now?
That's a lot better. Yes, a lot better.
Okay, I had a special case because I'm a maintenance guy to get my phone protected. I apologize for that.
Okay, that's much better.
Yes.
Okay, so do you want to repeat what you previously stated?
Yes, sir. Is I didn't know that I was gonna want the trial until just now earlier today. I kind of just now made that decision because me and Miss Hills, when I get information, when I share it between me and her, the information that she gives to me is fake. And I have the proof of this to show you, and she's done it multiple times. So it confuses me. And then I can't make rational decisions based off of the information that me and her are sharing. So because of this, I just want to go to trial so that I can show you what has actually transpired to this point. And then, and I don't feel like I'm even really involved in it anyway because everything gets twisted. So I prefer you just to actually you do it. And then I know I might not get but I'm a fair guy, and I think that it'll be fair. So I'm not really worried about it, actually.
Okay. Okay, before we set a trial date, Mr. Straub, Ms. Hills is entitled to your written answers to those interrogatories. So the court's question is, can you have those to her by the end of this week?
Yes, sir.
Okay, well, today's Wednesday. Do you need till the next week to do that? We're not going to play games
Yes.
here. I want a definitive date, but you need to sign.
So if I
complete
can
the
have a full
answers.
week,
Hold on. You need to sign. You need to complete the answers. You need to sign them before a notary, and then return them to Ms. Hills.
Okay.
Can you do that? What, a week from Friday, say May 10th?
Yep.
All right. How many interrogatories are there, Ms. Hills?
120 with approximately 20 with subparts.
Okay, 21. And can you do that by May 10th? That's a week from Friday, Mr. Straub?
Yes, sir.
All right, so ordered. Finally, there's a show cause before the court this afternoon which needs to be addressed. First of all, you filed a motion which was to vacate a divorce decree, and you didn't show up on your motion hearing. You scheduled for a hearing. You did not show up on April 3rd, and the court awarded Ms. Hills $520 in attorney fees. You need to pay that to her today. So it's 2:30. You got till 5 o'clock to pay that $520 to Ms. Hills. Mr. Straub,
Okay.
can you have that paid to her today?
Yes.
Okay. Finally, it's alleged you violated a prior restraint of his court, prior orders of his court, that you entered the home, or you went on the marital property and you took a boat and a trailer, contrary to this court's order that you not do so. What's your response to that?
Mr. Straub told me I could take the boat.
Where is the boat?
In my front yard. I have I have 90% of my awarded items. Ms. Straub has slowly given them to me, just not all of them. And the boat was one of them. And she told me I could take the boat.
Your Honor, I can clarify that. She did initially tell him on the 20th of March that he could take the boat. That was before she let me know that he had asked to do that. He had filed the motion to vacate the settlement agreement at that point. She then revoked her consent for him to come and get the boat until that motion could be dealt with by the court. He then failed to show for his hearing. The court denied the motion, and at that point, I did advise my client that she could start turning over that property to him. But on the 29th of March, he had no permission to be on the property whatsoever, or to take any property. The court had not heard that motion at that point.
All right, but was that the boat and motor ultimately awarded to Mr. Straub as part of the settlement agreement previously placed on the record?
It was.
All right. All right, so obviously there's some confusion there, some misunderstandings. So I believe the court's opinion that deals with that issue. Mr. Straub's in case he can pay $520 to Ms. Hills today. He's going to respond to the interrogatories by May 10th. Ms. Hills, anything else that needs to be addressed before we schedule a trial date?
Yes, Your Honor. We had at the last hearing, as part of the agreement pending today, left Mr. Straub as an authorized user on my client's Cabela's credit card. He has since, and part of the agreement was that he would be responsible for any charges after the date that partial settlement was put on record, and that she could make adjustments to the amount of equity owed to him if he failed to pay those charges to her. Since then, he has basically been running up the credit card, buying new large items of personal property, using the credit card far in excess of the status quo. The amount of equity that we believe will be owed to Mr. Straub, given Mr. Evans' historic and current appraisals of the property, with an adjustment for Mr. Straub's share of the marital debt, which had also been agreed to at $5,000 and change, she would owe him about $7,500. He has already charged up over $2,000 on that card. We're very concerned that he's going to keep going now pending trial. So she is asking that the court at this point in time, given Mr. Straub's failure to mediate in good faith today, which my client came here to do. We were hoping strongly for a resolution today. We are asking that she be permitted to remove him as an authorized user of that account, or at least that a cap be put on the monthly amount that he can spend and base that on the status quo. I think we'd probably need to talk to Mr. Walker about that a little bit. But our first request is that he be removed as an authorized user from that account, so she does not need to worry about that amount exceeding the amount of equity that she will likely owe him.
And that's Cabela's account, is that correct?
Yes, it is.
All right, Mr. Straub, your response?
My response is, first of all, how would I pay Ms. Hills if she shuts off the card? So she's setting me up right there. It's very obvious. In order for me to pay Ms. Hills today, I definitely need the card that I think I am going to use to do that. You know what I mean? So that would be my first worry there. And my second worry is there's no proof that I ran it up with excess. Where's the proof? I haven't run anything up. And also proof that I'm only going to be awarded $7,000 for a house that's $190,000, more like $75,000, not $7,500, $7,000. So I'm should be enough for it to cover it, and or I'm not poor. So I could cover it or borrow it from my father, but shutting that card out today would absolutely make it to where Miss Hills would 100%.
I'm not sure what the Cabela's account has to do with your livelihood, but the court's going to order that Miss Straub can remove you as an authorized user of that Cabela's card. So you privilege you from charging any more than that Cabela's card, Mr. Straub. Okay.
So I can't use it, or? That's
correct.
Okay.
It's not critical until we have a trial date. You can get a Cabela's card in your own name, but you're getting removed as an authorized user of this joint Cabela's card. Let's not complicate things.
Okay.
Ms. Hills, you still need to talk with Mr. Walker to reckon something else?
No, Your Honor, I'm satisfied with the court's decision. Thank you.
All right. Ms. Hills, from your standpoint, how long do you need for a trial? Can we do it in half a day?
I think we can do it in a half a day. Yes.
All right. How many witnesses do you expect?
My client and Mr. Evans would likely be the only two witnesses.
Okay. Mr. Straub, how many witnesses would you call at trial? Again, there's only 4 issues at trial: child support, spousal support, as well as the value of the marital home and your interest in that home.
Probably 5 people.
Okay. Yeah. Okay. You'll need to disclose the name and the address of those witnesses to Ms. Hills. We're going to establish a date which you must exchange the witness and exhibit lists. Ms. Hills, have you received a written appraisal from Mr. Evans?
Yes, Your Honor. We have 4 total appraisals, 2 historic, one from Mr. Straub's appraiser, one from Mr. Evans, and current appraisals from each as well. We have exchanged those.
Oh, so Mr. Straub has a copy of the appraisals in your possession, is that correct?
No, I do not.
Sent those, yes. And we will
You did not send me it. Yeah, because you didn't send it before and you keep lying. I'm sick of it. You didn't send it. You play games, and I have proof of it, and I'll send it to the court if they'd like to see it. She sent me fake ones, hence why she has to resend them. You did not send me a current appraisal. I sent you mine. You did not send me yours. Not very fair.
All right. The court's going to order that both the exchange exhibits and witnesses by a certain date. We'll address just a minute. Mr. Straub, you're going to represent yourself with this trial. Is that correct?
No, I'm trying my hardest to get a new lawyer. I called someone and they ghosted me, but I'm trying my hardest to get a lawyer for this. And if I do, I would request Ms. Straub to pay for that because she has the money to. And I don't. And I need to do a lot of discovery because they're not sharing the information properly, which I can show all of the information.
Mr. Straub, Mr. Straub,
Yes,
we have that attorney on board within the next 2 weeks.
Yes, I will.
Right. Ms. Hills, I know we need to move this matter forward, but the court's reluctant to schedule a trial date. In fact, if we have an attorney on board that says I can't do it on that date, what's your thoughts in that regard? Do we set a trial date today, or do we set another pretrial in 2 weeks to see whether Mr. Straub comes back with an attorney?
I don't have an issue with the credit card issue being decided, with coming back in a couple of weeks so that we don't wind up rescheduling a trial. I agree that that would be a concern. I would also, if there is an attorney, like to have input from, counsel regarding scheduling, order, information as well, deadlines, as well. So I don't have a problem with a couple of weeks. However, if there's not an attorney on board in a couple of weeks, then I would certainly be asking the court to set a trial date at that time.
Absolutely. All right, so Mr. Straub, what the court's going to do today, we're going to adjourn for a couple of weeks so that hopefully come back with an attorney so that we can coordinate a trial date with that attorney's schedule to give you the benefit of having that attorney. And the attorney can perhaps work through Eli's issues with Ms. Hills. Maybe he can help you facilitate a full agreement, which would be in your best interests. But in any event, the only order of the court today is that you respond and return the answers to the interrogatories by May 10th, and you pay $520 today. Court's also authorizing Mr. Straub to remove you as an authorized user of the Bell's account. So we'll give you some proposed dates for another pretrial. How about May 17th, 11 o'clock? Would you be available, Ms. Hills?
I'm checking right now, Judge.
Mr. Straub, it's a Friday, 2 weeks from Friday.
And this would be in regards to,
Just a pretrial. And again, hopefully you have an attorney here. If so, what I anticipate at that time, unless the attorney agrees he wants to meet with Ms. Hills, try to resolve this, the court would most likely schedule a trial date at that time. So if you don't have an attorney, the court's going to schedule a trial date on May 17th. When you come back, if you have an attorney, hopefully to review that attorney's schedule to make it an agreeable date and time for everyone, any trial date. And that your attorney may very well, I think any good attorney is going to say, I want to talk with and try to review things with Ms. Hills and attempt to reach our own agreement.
I can do
So
this.
the big question is, do you think you can have an attorney on board by May 17th? Give you 2 weeks from Friday.
yes, I am trying my hardest. I tried before, and I already called someone and they kind of just ghosted me. But I will continue to try, and I will try my best.
Okay. And you want to have that attorney appear then on May 17th at 11 a.m. That work with your schedule, Ms. Hills?
It does, Your Honor. It works well. Thank you.
All right. It'll be a Zoom pretrial conference. Mr. Straub will mail out you notice. You're still at 5951 North Ann Arbor Road, Dundee. Is that correct?
Yes, sir.
They will mail you notice to appear via Zoom for a pretrial, May 17th, 11 a.m. There'll be a final pretrial. Hopefully you have an attorney on board at that time. Then we'll go from there, but please make sure you pay that $520 to Ms. Hills by the end of today and answer those answers interrogatories by the 21st. I'm sorry,
Okay,
by May 10th. I'm sorry, a week from Friday. Okay.
Yep.
Thank you, Your Honor. I'll prepare an order.
All right. That will conclude this matter. You can all zoom out. This is Attorney Christina Hills representing the plaintiff Heather Straub. Ms. Straub is present. In addition, defendant Charles Straub is also present. Good morning, everyone.
Morning, Your Honor.
The court's aware that the proofs in the partial settlement agreement was placed on the record back on March 13th, 2024. And there appear to have been 3 outstanding remaining issues of child support, spousal support, as well as defendant's interest in the marital home, which was to be reduced by $5,436. Mr. Straub, it appears that we need to move us forward to a trial date. Will you be representing yourself at that trial date?
Yes.
Okay. The last order that the court entered back in May 10th was that the parties were to exchange appraisals. Did that occur, Ms. Hills?
I think Mr. Straub had indicated he hadn't received mine for whatever reason. Yes, we did re-email those to him on May 1st. We had already received his, so there was no issue with that.
Right. Okay. Now, did you receive the appraisal from Ms. Hills, Mr. Straub?
Excuse me. Yes, I did on the second
Okay.
time around. I did. Thank you.
All right. Also, Mr. Straub was to provide notarized answers to interrogatories by May 10th. Was that received, Ms. Hills?
We did get answers. They weren't entirely satisfactory, but we're not, I've spoken with my client. We're not going to be pursuing a motion to compel at this point. We believe we have what we need to move forward with trial.
All right, thank you. Mr. Straub was also ordered to pay $520 in attorney fees to Ms. Hills by May 1st. Did that occur, Ms. Hills?
It did. Yes, Your Honor, it did.
Oh, thank you. All right, and today's the final pretrial conference. All right, Ms. Hills, what do you anticipate? We'd try this in half a day?
I believe that I can easily complete my portion of it in a couple of hours. I would have Tim Evans and my client, who I believe would be my only witnesses, and some documentation regarding income, and most likely Mr. Straub's interrogatories as my only exhibits.
Okay. Mr. Straub, would you agree we can try this case as your main issues in a couple of hours?
Yeah, it shouldn't take longer than a couple of hours.
Yeah, are you going to call any witnesses?
I plan on calling at 3.
Okay, and who are those witnesses?
My mother, my father, and the woman who did the appraisal.
Okay, and yeah, you know the name of that appraiser, Ms. Hills?
I do. It's on the appraisal reports that he sent.
Right. What's the relevance of your appearance, Mr. Straub?
To show the value of the home, to prove forth the value of the home, in which Ms. Hills says it's worth 80,000 from her appraisals, and mine say 185. So there's a big discrepancy in the amount of value. And so the appraiser, I can have her come and say basically what comparables that she used in order to come up with her thing, and then I can have her compare it to her other, and and then I can ask, why weren't these comparables used, and then why is
Certainly.
there such a big discrepancy?
That's certainly, but the question is, what's the relevance of your parents? Are they certified appraisers?
No, they witnessed and or saw and or helped me to do all of the work that I had done to the home over the last 20 years. And they can attest to that.
Well, let's assume that. But again, you've been married 12 years. So
we were together for 10 years prior to that, and I lived in the home with Ms. Straub. I purchased the home with Ms. Straub. We've lived there together for literally 20 years. We've been together since we were like 18. And over that time, I've took the house from being a foreclosure all the way to being what it is today. And it's not just the value of what it's gone up, it's also what I've done. And most of the work I've done was while Heather worked, I stayed home and repaired that home and made it a beautiful home. And we bought this home to one day rehab it and sell it together to move on to a bigger, better home. So all I wanted is them to help assess that over the last 20 years, my father gave us money for our marriage, which was $4,000 and we use it to work on the home. And I built 2 additions off of the home with using that money. So that was why he's coming I could have him assess to that. And then also my truck, when I was a kid, when we first bought the home together, I sold my truck as a young kid that I inherited from my grandfather for us to buy this home together. But for some reason, the loan only let Miss Straub be on it, or we couldn't get it. So I didn't put my name on it so we could get the home. But I was in the room with all of the signing and all of the people. And then when we got into the home, it was a foreclosure and it was water leaks and the walls were falling in and this roof was falling in. And I over the last 20 years, I've done nothing but just rehab and put all of my time and effort into making this into a beautiful home. And I've almost completed it. I'm literally almost done. There's a little couple things here and there that were the finishing touches that I never got to finish because she stopped it. But there was nothing to say that I wouldn't have completed these and finished it to be the great home, and we could sell it and both made good money.
All right, Mr. Straub. So, Ms. Hills, is there an issue in terms of the premarital value? According to Mr. Straub, they purchased the home together, correct?
This was my client's premarital home. He is not on the deed. He is not on the loan. They were not married until 12 years ago. This is her premarital property. He has done some work on the home, and Mr. Evans will have a lot to say about how the improvements that he made actually decreased the value of the home over time. Unpermitted additions, duct work coming out the middle of a soffit in the kitchen, all sorts of things that decreased the value of the home. In fact, Mr. Evans' appraisals are the same from date of marriage as today. The amounts are exactly the same.
Right. Ms. Straub wants to retain the house. Is that correct, Ms. Hills?
Yes, Your Honor.
I mean, there's always a possibility the court can simply order the home be liquidated, and well, it's just a matter of dividing the net proceeds. I mean, that's always an issue, a possibility, is it not?
The court can do whatever it feels is equitable. We agree the court has those powers. However, we believe that the testimony is going to show that clearly that this was her premarital property. And I believe Mr. Evans is going to be able to provide very credible expert testimony as to the value of the home, both date of marriage as well as current value. And I believe that he is going to be able to completely discredit Mr. Straub's appraiser.
All right. Okay, so Mr. Straub acknowledges Mr. Straub has some interest in the home, though, for the past 12 years, correct? And it's just a matter of she's in position to, if the court, once court determines Mr. Straub's interest in that home, she's in position to compensate Mr. Straub for his interest in the home. Is that correct?
She is, yes.
Right. All right. Okay. We'll give you a couple dates. It appears that everything is ready.
Yes, Your Honor. We also have an issue of, it goes along with the spousal support and imputation of income as to Mr. Straub. He is making a spousal support request. He is unemployed, has been for the vast majority of the marriage. He is making the spousal support claim. So I just wanted to let the court know that would be an issue related to the spousal support as well. He is not disabled in any way, shape, or form as far as we're aware.
Well, any spousal support on 12-year marriage would be very short term, Mr. Straub. So you've got to have some testimony, documentation that you are disabled. That's the only basis in this court's opinion for spousal support. You appear to be young. Unless you got some physical disability, you need to get your feet on the ground. This is not a spousal support case.
I have a physical disability and I can prove it through MRIs.
You need some medical testimony, Mr. Straub.
Yes, sir. Yes, sir. I can bring the MRIs in that was done on my back, and then you can see the herniated discs and arthritis in my back.
I need medical
MRI.
testimony, Mr. I need medical testimony that you cannot do any type of work. You can't be a clerk at a gas station sitting in a chair. You can't sit at a computer. There is no form of employment that you could perform. That's what the court needs. Medical testimony, not your lay testimony, Mr. Straub. So I'm just telling you, I'm giving you, you may want to consult an attorney because I think you're going to be on the short end of any claim for spousal support. In any event, we'll give you a hearing date, and the court's going to want both parties to submit just a brief summary statement. A trial brief, maybe just a couple pages, Ms. Hills, 2 or 3 pages.
Yes, Your Honor.
So we'll give some dates. When do you think you'll be ready, Ms. Hills, with your schedule?
I would just ask for the minimum 30 days, Your Honor.
Court's it appears July 18th. I'm sorry, it's a ways off. Ms. Hills, you're available July 18th at 8:30.
I have a trial that day that I expect to go with Judge Arnold, Your Honor. I'm sorry, Judge Lohmeyer.
Okay. Let's see what we can try to do on Monday. Okay, maybe we can try to do it on a Monday if it's gonna be half a day. Normally the court would schedule trials on Thursdays, but I need to put it off so far. How about July 1st? Monday, July 1st?
I hate to be the squeaky wheel here, Judge, but I am planning on being up north that week.
Fine.
I'm working, but it would be difficult for me to do a trial from up there.
Not a problem. I know you got a very hectic schedule, Ms. Hills. No need for explanation.
I appreciate that.
What about July 8th, the following Monday?
Could we do the afternoon, Judge? I have a mediation in the morning with Mr. Walker, but the afternoon is completely free.
Yes, we could.
That would be great then. Does that work for you, Ms. Straub?
Mr. Straub, it's July 8th. So it's a Monday. It'd be at 1:30. Unless you're going to be out of town, Mr. Straub.
No, that's fine.
Okay, all right. Court will notice, Mr. Straub, you're still at Harbor Road, Dundee, 48131. Is that correct?
Yes, sir.
We'll mail you notice to appear. Ms. Hills, you want this in person?
I would prefer it in person if the court's okay with
Okay,
that.
that's fine. We'll do it in person. It'll be an in-person trial, evidentiary hearing at July 8th at 1:30 p.m. And Mr. Straub, you would agree the only issues are child support, spousal support, and your interest in the marital home. Is that correct? Those are only 3 issues that will be addressed?
I mean, yeah, all of the issues really. I mean, none of the issues that I've addressed.
Hold on, Mr.
have
Straub,
really
we put a partial settlement agreement upon the record. So that's.
So then,
you're
yeah,
bound
we'll
by
go with that. Then, yeah, then we'll honor that.
All right, so the 3 issues, and the court, when the Senate knows someone in order that both parties, you need to submit a written pretrial statement or a trial summary, Mr. Straub, where we set forth your position on these issues, so the court can get some foresight. And
When would that be due, Your Honor?
what do you suggest, Ms. Sills? Is would July 1st be too?
July 1st
Prior
would
to
be
July
perfect
1st.
for me.
All right, so trial briefs that due honor before Monday, July 1st. We'll put that in the written notice, Mr. Straub, written trial brief on it before July 1st. You need to file the original with the clerk's office, a copy to the court, and a copy to Ms. Hills. Ms. Hills will likewise provide a copy to the court and a copy to you.
Okay.
Any questions, Mr. Straub?
No, I'm sorry. Someone interrupted me. I apologize. No.
Okay. Again, it's up to you. The court would suggest that you do consult an attorney, but I know you've gone through a couple of attorneys. Anything further, Ms. Hills?
Not today, Your Honor. Thank you.
Okay, we'll see everyone back then July 8th, in-person evidence hearing, 1:30 p.m. Trial briefs due honor before July 1st.
All right. Thank you.
Now conclude this matter. We'll see everyone on July 8th then.
Thank you.
Thank you.
For the record, this matter is before the court on the plaintiff's motion for entry of a proposed judgment of divorce, as well as defendant's objection to or motion to rescind an ex parte order suspending his parenting time. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff Heather Straub. Ms. Straub is present, and defendant Father Charles Straub is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Okay, the court would like to first address the judgment of divorce that's been submitted. The court would note, having reviewed the judgment, that it appears to be consistent with the agreement placed upon the record, as well as the final rulings of this court during the trial conducted on July 8th, 2024. Mr. Straub has filed an objection to the proposed judgment, indicating that Mr. Straub has committed fraud by not following court agreed upon parenting time before divorce is final, and alienating the children from Mr. Straub. That she submitted a fraudulent appraisal, a real estate appraisal, and she lied on the financial disclosure statement. That she hid Mr. Straub's Coinbase account, admitting that. Court does not recall any testimony during the trial about a Coinbase account. And also that Ms. Straub did not disclose she was an operating partner at Panera. I recall testimony she was a general manager. And further that he should get alimony because of maintenance. All right, Mr. Straub, I'll let you address anything further, but those issues should have been addressed at trial. The judgment prepared by Ms. Hill seems to be consistent with the agreement placed upon the record by you and Ms. Straub some time ago, and then the subsequent trial on July 8th. It appears to be consistent. I don't recall you arguing for, you represented yourself at trial. I don't recall you arguing for spousal support. And in fact, the court's opinion is not a spousal support case. I don't recall you having any claim that the appraisal was fraudulent. As the court recalls, you had no objection to the appraisal. We had testimony from the appraiser. You had no objection to the admission of his written appraisals. So a lot of these issues were not raised at the trial.
Because I didn't actually have the information. I didn't have the information that she had committed, that he had did that until the trial. At the trial is when he committed his fraud, when he brought that appraisal. That was not consistent with the other appraisals and the other papers, what were they called? Market analysis that we got. And I told him that's why we never could make a deal. And I did say that this is way below the value, and I'm not going to make a deal with fraud. And I shouldn't have to even try to make a deal with fraud. And I mean, that's $100,000 below its actual value. That's actually like extreme fraud, not just like small fraud. And he should, I'm just saying, so I don't understand why that would even be accepted by the court considering how fraudulent it is.
But you have to object to the time, Mr. Straub. You did not, you saw the appraisal ahead of time. You could have gotten your own appraisal if you disagreed with it. Just because you disagreed with it.
I had a death in the family that chalked up my time here too a little bit. You know what I mean? And it slowed me down in dealing with some of my paperwork. And I had my lawyer withdrew, and I had issues with communication with her in the beginning. And that slowed me down a little bit, but I did communicate that her appraisal was far too low from the beginning, and 80,000 isn't even the value of the land that it sits on.
Well, first of all, your motion, the attorney withdrew back in February of 2026. The trial was held in July. You had plenty of time to secure another attorney, secure an appraisal of your own.
I have proof that the attorneys will not take my case. I have been recording it. I have called 3 attorneys, and they will not take my case.
Okay, but that's not the court's problem. The only question is, does this judgment accurately reflect the rulings of the court? The court does not believe there's any basis for a finding of fraud on the part of Ms. Straub. You did not submit any competing appraisals. As our court recalls, you did not really cross-examine.
I did cross-examine
him, but not significant cross-examination. So anything else you want to add, Mr. Straub?
No, sir.
Ms. Hills, do you want to respond to the motion?
No, Your Honor, I don't believe there's any merit to the objections. I'd ask the court to sign our proposed judgment.
Very well. Once again, for the third time, the court believes that the proposed consent judgment. Do you receive a copy of this, correct, Mr. Straub?
Yes.
All right. The court believes it is consistent and comports with the court's ruling and, for the most part, the parties' prior agreement on a number of issues. But currently, the court will sign the judgment of divorce, which means the two of you are now divorced.
When do I get my
we'll move on
belongings?
to, and Ms. Hills will mail you a copy of this judgment of divorce, Mr. Straub. Then the next issue is the ex parte order of this court suspending your parenting time. That was entered on July 11th. The court was provided with a copy of your voicemail message to Attorney Hills. And clearly it was very disturbing. You were very angry, and I understand people can be angry, but the court questioned whether or not you need a mental evaluation. As a parent, we need to make sure the children are safe in your presence, Mr. Straub. And obviously, I understand when you're upset, but you don't act that way. It really raises questions about your mental stability, Mr. Straub. That's why the court entered it. But the court set up for review today, so we can talk about this. And then, of course, you texted Ms. Straub that you'd be not exercising parenting time because it would not be safe for you. You're moving away. And then an hour later, you completely changed your mind. So obviously, Mr. Straub, what's going on?
I just had gotten paperwork with the court that said I finally got served that ex parte order. And I read it and realized, hey.
All right, Mr. Straub, hold on. This was all before the ex parte order. The court signed the ex parte order because of your conduct. Your voicemail message.
I only voice my opinion. I just want my bank accounts. And Ms. Straub has actually given me my bank account. She gave it to me like a week ago. And I have proof that she did that, and I can submit that, and I will with my lawsuit. But it's going to show that she 100% didn't give it to me until just the other day. And she did give it to me finally after I've asked so many times. And Ms. Hills multiple times told me she's not going to give it to me. And so that caused me a little stress because I need those accounts to finish doing this taxes thing. And that I know I keep talking about it, but I just need to do it. It's not like I'm hung on it or anything. It's just like legally the law. So I'm going to try and get that done so I don't have to worry about that. But other than my taxes, I got a job. I have a place to stay here at my brother's. I hang out at my dad's on the weekends because he's got a farm, and I play with pigs, and I have a garden. And I'm a pretty calm guy. I just not good with the court and being on Zoom. I get nervous. But I just want my bank accounts, and I'm not a danger to my children though. I just want to see them. I haven't seen them since Father's Day. I've tried, and I've asked Ms. Straub if I could just see them or talk to them, even on the phone contact, and I don't even get phone contact, which I feel like I should at least get to speak to them on the telephone.
Mr. Straub said you can't leave threatening messages to people.
I'd never threatened the children, and I never left a threatening message to Ms.
No,
Hills.
hold on. I didn't say you threatened the children. You threatened Miss Hills.
No, I did not. I told her I need my taxes and I will sue her. And that is, I can do that. I can threaten lawsuit. I can threaten her to do the right thing, which is give me back my taxes. I never threatened her like with physical harm or hatred or nothing. I just want my taxes back. They're mine. It's my stuff. That's all it is. And it kind of just causes me stress that nobody else cares. And I understand. I guess it's not that big of a deal. As time goes on, I realize it's not that big of a deal. Seeing my children is a big deal. And I would just want it to go back to normal with my children and my life.
Your Honor, may I
Ms. Hills,
say something?
hold on. Miss Hills, do you know what Bank County's talking about?
I'm not sure which one he's addressing. That was a week ago. My client could address that better than I could, but going back to, there was an issue relating to a cryptocurrency account, and I believe there's a Robinhood account. There's one other account. We established the day of trial that two of those were solely in Mr. Straub's name, and that he would be the only one with access to those accounts. My client
did
could
not say
not
that.
provide access to those accounts for him. And if he were locked out because someone lost a password or something, he should just be able to contact those companies. And the court essentially awarded both of those accounts to him. The Robinhood account was to be split equally between the parties. Ms. Straub, is that the account that you shared with him recently?
No. So the Robinhood account is what we're going to split equally. But the Coinbase account that he keeps talking about, the reason we're having issues is because—
What about Maggie? TD Ameritrade, Maggie.
Hold on, Mr. Straub. Mr. Straub, don't interrupt, please.
Sorry,
Let her finish. Let her finish, and I'll let you respond.
Thank you. So the Coinbase, there was a discrepancy because it's under my email, but it's under his name. So like when you go to sign into something like that, because it's been so long since we have, it wants you to verify your identity. I am not Charles Straub, so I cannot verify my identity. So he kept asking me, and this was brought up in the trial. And you had yourself said, well, that wasn't put on the financial disclosure, so it is what it is. Well, after that trial, I decided I am going to call Coinbase and I'm going to get into it so that since it's in his name, I will change it to his email and he can have it, because I was trying to be nice. So I got that for him. I even texted him. I said, what email do you want me to have them put down so it's all yours? And he said no. And he's now threatening to sue me because I was holding it from him when I was just trying. Like, he can have it. It's literally like, it's like 1,000. He can have it. I don't want it. I was trying to help him. The TD Ameritrade that now he's talking about was also brought up. There's $52 in there. Once again, at the trial on July 8th, you had said it wasn't on the disclosure, so it is what it is. That is in my name. But heck, if he wants to go for it and split that $52, I don't mind. But this is pointless. And as for the taxes that Mr. Straub keeps saying, I have text messages. I did do our taxes, but he also did accept the check for half of the tax refund, and he cashed it. So that is gone. It's over with. I have proof saying that he is going to accept it and be done with it. He cashed the check. I have proof. That's done. Like we filed like it was a joint tax return. Everything's done. That's over with.
That's correct. That was part of the partial property settlement.
I never signed my taxes.
And he accepted as part of the partial property settlement that was the case, that there had been a joint filing. And he acknowledged at the trial, the day of trial, that he had received his share of the proceeds of the tax returns. So I have no idea what he's talking about with regard to filing his taxes. They are already filed, and that's been dealt with on—
Yes, it's been filed by Ms. Straub without my signatures and without my authorizations. That's what I've been saying. She can't do that.
Well, it was not raised at trial, Mr. Straub. That issue's been addressed, but now the bank accounts, yes, you were awarded those two accounts.
The fraud you can't address it when it's fraud. And it's, even if I accept it, it still doesn't change the fact that's felony bank fraud or felony tax fraud. The IRS is going to be interested in the fact that she stole my identity. And then what about the the forgery part.
I
We
do
haven't
our
addressed the
taxes
fact that there was
every
forgery.
single year. I did them the same way with the same company, the same way I always do them. I didn't do anything maliciously. Nothing.
So they had my
was
signature
wrong.
on file and she e-filed it.
It's
I
a-
have proof that I wasn't in your presence when you did it,
Right.
nor did I know.
Those issues are the water over the dam. Those issues that could have been raised at trauma job. They were not. It's not an issue anymore. Again, terms of the settlement and the divorce are set forth in the judgment. So read that judgment. If you need access to an account, Ms. Straub said she emailed you and asked for what email address you want. She's trying to help you so you have access to those
No,
accounts. You can close them out.
she had them first in her access. How did she get them in the first place? That's why she can't give them back, because how did she get them?
We
then
got them
and it won't let her-
together.
They were married. That's
We
all.
were married. We did it
Mr. Straub,
together.
she's trying
But you
to.
admitted that you have access. You went in there and gave it back to me. You admitted that you have access, so you had it. So you
Mr.
could give it
Straub,
back.
Mr. Straub, she's trying to give
These
you
are
access to the
felonies.
accounts.
These are felonies. This is felonies. There's a laundry list of felonies. I mean,
Mr.
this goes on
Straub,
and on from the beginning.
Mr. Straub, can you please listen for one moment? She's trying to give you
Yes,
access
sir.
to the accounts. You want help with access to the accounts?
She's not. You've said this over and over. She doesn't actually give me the access. She plays a game, and you don't see it, and she doesn't actually give me the right codes.
Ms. Straub, you just need
What?
an email address, correct?
I need passwords, email addresses, and access to all three of the bank accounts,
Okay.
especially the ones in my name. And I should have had them from the beginning, and she should have disclosed this from the beginning. And this, just so you know, in my objection for that she lied in her disclosure agreement, that I can bring that up now, because that wasn't on my initial one that I didn't
You
show
have
up
it on
for.
your disclosure?
It's a new objection. It's a new objection. It's new evidence showing that you lied, and I submitted that in the evidence that
Okay.
you lied on your disclosure, and you never said
Mr.
nothing about
Straub,
crypto.
Mr. Straub, Mr.
Yes.
Straub, I'm gonna mute you if you don't stop talking. She wants to help you give access to the accounts. Give her an email address and she can make that happen.
She has my email address. So does Ms. Hills. How do you think they've texted me this entire time?
I'm not gonna resolve this on your behalf. I'm trying to make it easy for you. You can hire an attorney and you can take whatever action you want. So
Yes,
the
sir.
judgment of divorce has been signed. I'm trying to help you work through this, Mr. Straub, but you are not willing and you're not being reasonable trying to help work through this. Ms. Straub has explained, and you obviously are not listening. Okay, the last issue is parenting time. The judgment of divorce provided that that dad had parenting time Monday and Tuesday overnights, Friday overnights until Monday. It's a pretty significant parenting time part of dad. Mr. Straub, with whom do you currently reside?
I live at my brother's house.
Okay, how many bedrooms does it have? Who else lives there?
It has three, just my brother. It has 3 bedrooms, and it has a garage area, and it has the living room, and it has 2 living rooms. I actually stay in the second living room. It's like a bedroom. But I also stay I go and visit my parents on the weekend, but I live here at my brother's, and there's a girl's bedroom because my brother has a daughter, Kinsey, and she misses my kids because they.
Hey, where will the children sleep if you
They
have
have beds.
overnight parenting time?
They have beds in the bedroom and dressers
Home,
and
your
everything.
parents' home or your brother's home?
At my brother's home.
Okay.
They have all kinds. They have great setup here.
Ms. Straub, are you familiar with that home?
I am, and they actually, the last time they were there, they did not have a decent place to sleep or dresser or anything, which I actually filed a complaint with the friend of the court and showed pictures of what my daughter was sleeping in.
I mean, there's not beds for the children, Ms. Straub?
There was definitely a bed. She actually had her own individual pull-out cot that pulls out when she shows up. That's just for her. So not only did she have a bed, she had her own individual bed. And she just took a picture of it when I was making. It wasn't made. I didn't have the sheets on it and stuff because I do that new form every time they show up because they leave in between. And I like to keep the bedclothes nice for them when they show up.
So the two girls will sleep in the two girls sleep in the same bedroom and Colton has his own bedroom?
Yes. Yes.
Right.
Yep. And I mean, and when they come more, they can set them up more because, they haven't been here, but like a few times in the beginning. But once they get here, they have them and they can set them up however they'd like.
Yeah. Ms. Hills, the court's aware, Ms. Bars provided the court's recommendation that dad's parenting time be supervised at Family Counseling Shelter Services. Court's reluctant to adopt that. There's a waiting list, and there was actually no issues regarding dad's parenting time until such time as Mr. Straub left these disturbing voice and angry voicemails to you. That's what really created the concern of the court for his ability to parent the children. presumably he's got a relationship with the children. The court wants to maintain that. What about the parenting time? We can, the overnight at his parents' house till he gets satisfactory proof that his brother's home is satisfactory for the children?
Your Honor, we're asking for some supervision here. I would need to talk to my client if we were looking at a different supervisor other than family counseling. There was yet I'm still concerned about Mr. Straub being all over the place in terms of his emotions and his actions. He's clearly extremely angry still about everything related to this divorce. He did exhibit paranoia. He declined visitation with the children for at least a couple of weeks due to that paranoia following Father's Day and until we filed the motion. He said in text messages he was scared enough that he was moving away and to tell the children that he's sorry. And within an hour of that, he's saying it's all good and I want to see my kids now. That is not normal, rational behavior, and it certainly causes concerns with regard to the children's safety in his care. There was yet another voicemail, very angry, profanity-laden voicemail left for me on July 29th. I would be happy to play that for the court as well, but my client has major concerns. If the court is suggesting that parenting time be supervised by his parents, I would need to discuss that with her and see if she had any reason to believe that that might not be a safe situation. But she is extremely concerned about the children's safety with the state of mind that Mr. Straub is in currently.
Right, Mr. Straub, can you exercise this parenting time at your parents' home?
I mean, if taking the kids to my parents instead of my brothers would suffice and make them happy, I could take them anywhere. My family wants to see the kids.
I'm asking you, Mr. Straub.
Yes, sir.
Do your parents have room for these children? Do they have beds for these children?
Yes.
Can you exercise your parenting time in their home?
Yes.
Okay. And who else lives in your parents' home?
My mom and my dad. That's it.
Okay. And how many bedrooms do they have?
4.
Okay. So you could be there and the children, correct?
Yes, sir. My dad actually bought brand new beds for every single one of them and new dressers because he misses them really bad.
All right. I'd like the court to explore that, Ms. Hills. Do you want to talk with Mr. Straub in a breakout room regarding that prospect until Mr. Straub can convince the court that other overnight parenting time locations are appropriate, that to be in the home of the paternal grandparents? You want to talk to Mr. Straub about that?
Could we address the issue of the psychological evaluation prior to going back to discuss that? I think that could have a bearing on my client's position on things. We believe, even just based on his behavior today, as well as what I've just described, the additional voicemail that he left for me, even already knowing that was a concern that we had, it just causes us to believe that he is not mentally stable and should be evaluated at his cost. He says that he's going to have health insurance of his own within a matter of about 20 or 30 days. Certainly, if he's not insured, he could go to community mental health in whatever county he's living in, maybe Washtenaw. But we believe, based on his extremely erratic and angry behavior, that he needs to be evaluated.
Well, the court understands emotions are raw right now. Mr. Straub is upset, and the court agrees his anger is a legitimate cause for concern, but has there been a history of inappropriate action by Mr. Straub toward his children? If not, the court's not inclined to require a mental evaluation. If in fact there's an incident that comes up, by all means, we've got something we fall back on. If there's an issue with the way Mr. Straub is interacting with Ms. Straub or the children, that obviously is a basis to modify parenting time. But at this point, unless there's a history that you can point to, other than just the recent angry position of Mr. Straub, the court's not inclined to order that he undergo a psychological evaluation. But I'll have you talk to Ms. Straub, and I've got a couple of people waiting right now, Ms. Hills, if you don't mind.
Sure.
Mr. Straub, we're going to put you in separate breakout rooms.
Do you want Ms. Brower as well?
Do you want Ms. Brower to talk with you, Ms. Hills, or just you and Ms. Straub?
Ms. Brower as well, please,
Okay.
if she's available.
Do I need to leave to go to this breakout room?
We're gonna put you in a different breakout room, Mr. Straub, so,
Okay. Do I have to leave to go into that?
no, just, we'll take care of it. The parties have all returned for this Zoom review, the remaining issue, that being parenting time. Ms. Hills, is your client opposed to Mr. Straub, the father, exercising his parenting time with the children in the home of the paternal grandparents?
Your Honor, our first choice, if these were choices, would be to follow Ms. Brower's recommendation of parenting time at family counseling and shelter services. Absent that, my client, her second choice would be for parenting time to be at the grandparents' house and supervised by one or the other or both of the grandparents, and that the parenting time be every other weekend for the time being, pending the review hearing, which Ms. Brower had gotten, which I believe is at the end of October. Again, we would also be asking, in the absence of a psychological evaluation being ordered, that the court consider ordering Mr. Straub to take anger management classes. I think the court has been able to see his anger for itself today. It is clearly visible in the voice messages that he is leaving at my office. I'm pretty tough after 30 years of doing this. He doesn't hurt my feelings. But it certainly sets forth his state of mind, and that is a state of extreme anger at this point. Again, that it's concerning for the children. If anything were to happen, he would not be the first person ever to take his anger at an ex out on the children. That's what we are trying to avoid. So we would ask that the court consider ordering anger management counseling for him, and that he provide proof of completion of that to the court. He also, we're not certain if he had actually received notice of the ex parte order when he did this, but he showed up at the house after having not had the children for at least a couple of weeks. And basically, while they're in the yard, attempted to pull them into the car and get them into the car to go with
It was
them.
my parenting day. That was my parenting day and time.
Mr. Straub, I'm gonna mute you if you keep interrupting. You're shooting yourself in the foot, Mr. Straub, every time you open your mouth.
Sorry, sir.
The children were very reluctant to go with him, to say the least, and very concerned about him attempting to get them into his vehicle in that manner. So I think that further shows evidence of his instability at this point. So if the court would order supervised visitation, that's what she is asking for. First choice, the center; second choice, his parents. But certainly something needs to be done to address this anger. I'd be happy to play that second voice message for the court if you would like me to. It was as angry, if not more so, than the first one that he left for me, which I played for the court at the time of the ex parte review of the motion.
Thank you, but the court did, of course, hear the initial voicemail, and yes, it was clearly disturbing. In any event, Mr. Straub, are you agreeable to that your parenting time occur in the home of the paternal grandparents, and that one of the grandparents be present at all times?
I would prefer I could just watch them on my own. I don't have, because then I'd have to inconvenience my parents, and I'm trying to live a normal life, and I just miss my children.
The court's not going to allow that, Mr. Straub. So I'm just asking you, are you opposed to that?
So if that's what I have to do, yes, my parents could be there when the kids are there. Now, would that be temporary or permanent?
Well, until you can show the court that you have some stability, and you just don't grab the children and try to force them into a vehicle. I'm so disappointed to hear that. That creates nothing but stress and anxiety on behalf of children, Mr. Straub.
That was my turn to take the children. You're not listening. That was my turn to take the children with me. It was my day and my time. And I merely pulled in, and they ran out and got in my car. I swear to God. And then Ms. Straub ran out, and I left because I didn't want to have contact with her. That's all that happened. I promise. And then I got the order like the next day.
Did she know you were coming? Did Ms. Straub know you were coming?
Yes, I told her that I'm coming, and I said until I get the actual order, I'm got to show up to make sure I showed up for my parenting time. And that's all I did. And I backed in, and the kids ran out and got in my car. And then Miss Straub ran out, and then I told them, get out, never mind, go away. And then I left because I realized she wasn't being just civil about it. And I just really wanted to see the kids. And I hadn't gotten that order yet. So I wasn't stealing them, I promise. I was just trying to see them is all. And that's why I want to, like, if we could do this meetup, maybe not at her house, like in a neutral location. And I think that could help prevent that.
Okay. What about the, what's your response? Are you willing to secure a mental health evaluation for the benefit of everyone?
I mean, I haven't done anything absolutely at all wrong. I just
Okay,
merely,
Mr. Straub, right, obviously the behavior exhibiting is inappropriate. It raises concerns on the part of the court as independent that you can properly provide for these children by yourself.
could I,
And I
if now what
understand
I,
there's raw emotions with the divorce, but you got to control yourself.
yes, sir. Okay, so if I could just get my 50-50 custody, I would agree to anger management, and I'll complete that. I have no problem with that. You know what I mean? I feel like I could probably do the anger management. I mean, that's probably appropriate. And I'll
All right,
complete that.
at this point in time, the court will order that the defendant father's parenting time be at the home of the paternal grandparents and supervised by one of the grandparents at all times. So he can't, one of your mom or dad has got to be there when the children are with you.
Yeah, I know.
And your parenting time at this point in time will be alternating weekends. We'll start with this weekend, coming weekend, alternating weekends, Fridays until Sundays. And the court's can order you to complete an anger management counseling program, and the court will review your parenting time October 29th at 1:30.
So
If there's any further incidences, the court's going to require a mental health evaluation. At this point in time, I want you to complete an anger management counseling program.
Absolutely.
You got to control your emotions, Mr. Straub. This Friday, Miss Hills, what time would you suggest pickup and drop-offs? 6 on Friday, 6 on Sunday?
Ms. Straub, does that work for you?
That works for me.
She's indicating yes.
And who will pick up and who will drop off?
Shoot, I don't recall if we addressed transportation in the judgment or
Miss
not.
Straub should do
It
both
did.
because
It
I have
said
no
that
money.
it should be curbside pickup.
I have been getting
the parents
stonewalled
starting
on this
parenting
whole
time
thing.
shall pick up the children in the other parent's driveway or curbside. So we'll continue with that, Ms. Hills, if it's
Yes,
agreeable.
Your Honor. There's no reason to
All right.
change.
So
I do not feel safe picking up the children at Miss Straub's. I have said this many a times.
curbside. She's not
guys
going to leave the
ignore
home, Mr. Straub. You pull in the
Yes, sir.
driveway. You don't leave and you get out of the car, and the children will
No,
be
we
sent
should
out.
meet in a neutral place that's halfway between, like at McDonald's or something. I don't feel safe going to that neighborhood, and it's belittling to me. I used to live there. All my friends and neighbors live there, and they got to see me go there and pick up these kids. It's like shaming me. I don't feel it's
Okay.
appropriate.
If
All right.
he would like to meet in Dundee, McDonald's as drop off and pick up, I am fine with that. As long as
Thank
it does
you.
not, like if I'm working, like, you know, I'd have to send like someone else, but I'll have to try to move my stuff around, but I am willing to meet at Dundee McDonald's if that works for you. If that's okay.
Mr. Straub?
Yeah, that's absolutely okay. That's exactly what I
Okay.
asked for.
All right. And two of you should not have any contact. Just let the children out of the car. You park some spaces away, walk well, you got to be careful. It would be better to meet at the Dundee Police Department?
Well, should I just have my mom get her? Because I think she's got to be there the entire time anyway. So she should just go pick her up.
Okay.
I would be fine with his mom picking up. I mean, does she still want to, you want her still to meet at McDonald's?
Well, since his parenting time is supervised by one or both parents, then they would need to be in the car with him anyway.
All right. That'd be appropriate. All right.
Okay, so his mom- I would meet your mom at McDonald's.
Is your mom willing to do that, Mr. Straub?
I'd have to talk to her, but I'm sure she wants to see my grandchildren. I'm sure.
All right. So we'll just provide that the paternal grandparents will provide the transportation, the pickups, and drop-offs. That'll be at McDonald's parking lot in Dundee, 6 o'clock on Friday, 6 o'clock on Sunday. And Mr. Straub, in front of the court, perhaps can give you a list of recommendations in terms of the anger management counseling program or district court probation. They can give you recommendations of appropriate anger management counseling program. So the court will expect of documentation showing you completed that when we come back October 29th. if you, especially if you want to reinstate more parenting time. So this will be alternating weekends, Friday 6 to Sunday 6, till we come back October 29th. If there's any incidences, the court's gonna require a mental health evaluation. Mr. Robbie, you got to accept you're now divorced. You are now divorced. You need to move on.
Yeah, I have no problem with that.
And for the benefit of your children, the children don't need the drama, the stress, the anxiety that you create when you are acting angry.
These are not true accusations. They are not
Right.
true. You are deprivating my character.
Right, anything
She
further
has
this
committed
afternoon,
crimes
Ms.
against
Sills
me,
or Mr.
multiple
Straub?
felonies,
No,
and
Your
you
Honor.
have ignored them with impunity. So
You have
I've
anything
not
else,
been
Ms.
treated correctly, and
Sills?
I object to
Oh,
this
Your Honor, thank
entire
you very
thing.
much.
Mr. Straub, do you have anything further?
I object to this. This is not right. You should resign because this is not right. You've treated me very unfair. I have
Okay.
not done anything to lose my children. You robbed me of all my money and let my wife commit felonies and crimes against me that I have proof of. And I do not understand. And then you say my reaction to the crimes committed to me is me being crazy. That's just strange.
All right, you can consult an
It is.
attorney, you can appeal the decision to the Michigan Court of Appeals, Mr. Straub, but
Absolutely.
let's try to move
I will
forward
do
in a
that.
positive fashion. The court did not grant adopt the recommendation is that supervised parenting time, and you're gonna be on wait list for 6 or 8 weeks. I want you to have a relationship with your children, Mr. Straub. I want that. I'm trying to work with you, give you every benefit of the doubt. Rest assured of that. With that, the court will adopt the revised recommendation. Copy of the council. We'll see everyone October 29th at 1:30.
Thank you, Your Honor. I hate to ask it, but is Ms. Brower doing an updated?
Yes, yeah, I'm sure she will.
Okay,
Yeah, we'll do an updated rec and the court will adopt that. So again, this Friday, Mr. Straub, have your mother or dad to pick up the kids at McDonald's at 6 o'clock. And
Okay.
then meet Ms. Straub so she can pick them up on Sunday at 6, okay?
thank you, Your Honor.
Okay.
Thanks, Ms. Brower.
You're welcome.
We'll try. We'll come back and talk about it in October. All right, thank you, Ms. Brower. All right, everyone can zoom out. That will conclude this hearing.
Calling the matter of Heather Straub versus Charles Straub.
For the record, this matter is before the court this afternoon for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Christine Hills, representing the plaintiff mother, Heather Straub. Ms. Straub is present. Defendant father Charles Straub is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have conferred this afternoon with Mr. Walker from the front of the court. Recommendation from Mr. Walker should be forthcoming.
Yeah, Your Honor, I'm trying to get the recommendation to your queue. It's taking a little bit longer than normal. Just 1 second.
Okay.
All right, you should have that now, Your Honor. I apologize.
No problem. Yep. All right. The recommendation from Mr. Walker from the court is as follows. Defendant father shall have supervised parenting time at family counseling shelter services. Parties shall pay for their own intakes. Father shall pay for all sessions. Further, father shall complete a psychological evaluation paid by insurance or by plaintiff if not covered by insurance. A review hearing may be scheduled by Mr. Straub after the psychological evaluation has been completed. Obviously, this is a change from our last order of August 7th, where father had parenting time, alternating weekends supervised by paternal grandparents. Obviously, something has happened in the interim, Ms. Hills.
It has, Your Honor. Mr. Straub has had a falling out with his parents, which appears to be centered around his father attempting to get him to admit himself to St. Joseph Hospital in Ann Arbor or Ypsilanti for a psychological evaluation.
And so the parents cannot agree upon anyone else to supervise parenting time. Is that correct?
That's correct. There is no one else. Mr. Straub is living with his brother currently. His brother is unwilling to take on that responsibility, and there is no one else. And frankly, I believe that a professional setting is the best for this situation currently, anyway.
All right, so you're asking the court to adopt this recommendation, Ms. Hills?
Your Honor, I do have concerns about asking my client to pay for the psychological evaluation unless it's covered by insurance. It is not my understanding that Mr. Straub has insurance. So he indicates that he's living in Monroe County. He would be able to get an evaluation, or at least get some treatment started with Monroe County Community Mental Health at no cost to him as someone who's uninsured, or they would refer him to someone if he's able to get Medicaid who would accept his Medicaid insurance. He does indicate that he's working. As the court is aware, child support right now is set with parenting time at 50-50, 182 and a half overnights each. He is having no overnights of parenting time currently, so my client is having to pick up the slack of the 50% of the time that Mr. Straub would otherwise have the kids if it weren't for the issues that he's having. So I do not believe that it is fair or equitable to ask my client to pay for a psychological evaluation for Mr. Straub. We did have an additional request. Mr. Straub has taken to messaging my client in the middle of the night, primarily between the hours of 1 and 3 a.m. She has actually had to turn off notifications because it was so disruptive of her sleep in the middle of the night. So we are asking that Mr. Straub not message her at all between the hours of 9 p.m. and 6 a.m. And given that one night he messaged her 48 times, we're asking that he not message excessively either.
Right. Any objection, Mr. Straub, that you not communicate with Ms. Straub or text her between those hours of 9 p.m. and 6 a.m.?
I have absolutely no objection to that.
All right. So, Ms. Walker, if you can add that to recommendation that the defendant shall not communicate with text, phone, text, or FaceTime Ms. Straub between the hours of 9 p.m. and 6 a.m. each week. All right. All right. Thank you, Ms. Hills. Mr. Straub, do you understand the recommendation?
Yes, I feel like I've fulfilled what you guys wanted from me before, and I definitely feel like there's no need. The only problem in my life is that I really miss my children, and I want to get back to having a normal relationship with them. And I had no problem. The falling out with my father had to do with my father being an alcoholic and he's drinking, and it had absolutely, and I didn't feel like it was a safe environment for my children. And I don't stay there. I only stay there because of the the recommendation for you guys to have me watched, whatever it's called, for the child care. But I was a stay-at-home father with, and Ms. Straub trusted me for, the kid's whole life to stay home with them and watch them and take care of them. And other than our divorce, absolutely nothing has changed. And I feel I have a job. I took the anger management. I started going to church, which I haven't found one that up here that I went to in Tennessee, but I'm going to. But I feel like my mental health is great. I just would really like this divorce to finally end, and so I can.
Divorce is final. Mr. Straub, divorce is final.
Well, I mean the child custody, where I haven't been able to see my children.
Okay. Well, obviously, if the court, first of all, Mr. Hills, did you receive a documentation that Mr. Straub completed anger management counseling?
He did complete an online course, which he had been doing somewhat better when my client agreed that that would be acceptable. Since then, again, the middle of the night messages, the 48 on one night, and more messages, not to me recently, one since the last court hearing, but he's left a message for Tim Evans, threatening litigation against him and very angry. He has involved Miss Pastrana, accusing her of being part of the mafia. She's simply trying to get him his share of my client's 401k. Just very erratic and unstable behavior. He has this story about being in Tennessee with some very hard to believe things that supposedly happened to him down there, which appears to be some sort of a psychotic break that he's had. So we don't feel that the anger management that he did was sufficient to address his, what we believe, ongoing mental health issues.
Right, Mr. Straub, obviously, Ms. Hills, your client should know her future former father-in-law. Is he an alcoholic?
I mean, he drank. Do I know if he's an alcoholic? I wouldn't say. I mean, he works at GM and he's worked there for a long time. He's always seemed like a good guy to me.
Okay.
And the parties did both agree to use him as, along with Mr. Straub's mother, as a supervisor for parenting time. So Mr. Straub They had no concerns
have-
when that was agreed to.
At the time I was staying with my brother and I wasn't aware of their problems. And as a good father, when I did become aware of their problems, I even gave up the little bit of parenting time I had to make sure that they were okay. And that's what a good father and responsible father would do. And that's why I feel like with fulfilling everything the court wanted up to this point, proving that I'm a good father by making that hard decision, I feel like, and now that I'm back at my brother's house, now that I don't have to do the supervised visitation, the kids have a room, they have food, they have bedding, everything in our lives can go definitely back to normal, where can continue to have the bond with my children that I had their whole lives.
Mr. Straub, you have exhibited conduct which is of concern to this court, especially as it may affect your children. The fact that, first of all, after the divorce finalized, you blew up and threatened Miss Hills, and then, of course, why someone would text someone 40 some times in a given night is clearly suspect and unreasonable and inappropriate. The fact that you would reach out to the appraiser after the fact, or to the attorney that's preparing the qualified domestic relations order of all of concern to this court, and the court believes that your parenting time, since your parents won't do it anymore, that things have happened, your parenting time shall be supervised at Family Counseling Shelter Services. So you need to call them today and schedule that intake. Do you have their phone number? We want you to have contact with the children. Mr. Walker, do you have their phone number, Ms. Hills? Right, you have a piece of paper and a pen, Mr. Straub?
I refuse to be further tortured and ridiculed by this court. And if you order me to do that, I'm just not going to see them. Because I don't feel like you have proved any proof of anything Ms. Hills has been saying. It's all hearsay and it's lies. And threats of litigation are not physical threats, which she admits that those were not physical threats. And so I'm not really sure why the recommendation of the court is even what it is. And I definitely feel like I'm being picked on and discriminated against.
Mr. Straub,
if I take that recommendation,
Mr. Straub, who would text someone 40 times in a night? Do you deny that you texted her 40 times in one night?
She texted me back asking me for food money and saying she didn't have food for the children.
No.
Have you seen the text? I have the proof of it.
I have them.
And what was that? Was I threatening you?
No, but 48 times between the hours of 12:30.
So they were not threatening. You filed divorce 5 times, Heather. How did I know you're being serious this time?
All right. The court. I will set a review date, Mr. Straub. I want to keep this on my docket. I want to reestablish relationship between your
I know you want to keep me on here and keep me strung along, and not just let me move on with my life.
Time shall be supervised. Family Counseling Shelter Service. Call them as soon as possible. Schedule those intakes. Set those sessions.
I refuse to do it. I refuse this.
All right. The court will also file the complete psychological evaluation. Period. Will not order that plaintiff covered right now. We'll reserve that issue, Mr. Walker.
Then I will be moving out of this state because I am being discriminated against by this court.
Absolutely,
100%. You have proved no proof that I'm a danger to anyone, but you guys have proven that you are willing to step all over my rights and discriminate against me.
Do you want a review date in this court's docket?
No, I don't.
All right, okay.
Then I will not see my children ever again.
It's unfortunate you're taking that position. That you contact community mental health and meet with someone.
I will not see my children ever again if you continue to step over my rights with no proof that I have a danger to anyone.
Right, so the court will adopt the recommendation. Mr. Walker had 2 things. There should be no phone calls or text messages between the hours of 9 p.m. and 6 p.m. from the defendant father to plaintiff mother, and father shall secure a psychological evaluation, period. He should be able to get that done by community mental health. I'm sure they can help him with the.
Well, have a good day because I'm moving to Virginia.
With that.
Goodbye.
And we will not set a review date. Mr. Straub does not want.
I'm not going to do the review date because I'm not doing. You are doing this without any proof that I am a danger to anyone. I have done nothing but prove that I am a great father. I am a great person. But you will have proven that this court is willing to violate my freedom of speech and my rights based on lies from whomever to try and punish me for absolutely nothing, which this is actually torture. You're not letting me see my children with no proof that I'm a danger to anyone. And so the only way I'm going to get my rights is clearly to move out of this state, which I am willing and prepared to do. And I'm telling you right now, that is what I'm going to do. So by you making this recommendation, you are now turning me into a deadbeat father that you have desperately tried so hard to turn me into, which that I have proof of.
Well, the court does
And
not agree
I'm
with you,
sorry to
Mr.
make you mad.
Straub. Maybe talk to an attorney. The court wants nothing more than to
An
maintain
attorney,
relations between your
so what
children.
would the attorney
That's why the
change?
court was
Would the
wanting to
attorney
place it on its
change?
docket, and you did
What would
not
he
want
tell
to
you?
put it on the court's docket. So that will conclude this
What?
hearing.
Yes, have a good day.
Thank you, Your Honor.
It appears Dad was serious about not seeing his children. That was the last hearing for them in both Odyssey and my archives, and they have no further reviews scheduled at this time. I hope Dad comes to his senses and does what the court asks of him to have his parenting time restored for his children's sake. It's sad to see him so angry about the divorce, but I do wonder how much of his anger and instability comes from the fallout, or how much of it actually led to the divorce. I'll keep an eye out for any new hearings. Thank you for watching.